compelling circumstances, I am mentioning one matter, in connection with a preemption case, though a revisional application is pending, since the special bench issue is there involved, but the execution is being proceeded on the same now the date is being fixed for delivery of possession.
When?
That is fixed, that was fixed yesterday. Somehow the police authority came and give us 3 days time. But problem remains, your lordship appeared in this matter. That's why kindly release it by today. Otherwise, I could not able to.
Unless it appears, it cannot be released.
Why a supplementary list at 2 p.m. If for the purpose of release only.
You file it under.
Yes, I will file.
File, give the number. File to the supplementary list.
The number to provide করে দিচ্ছি আপনাকে file করে.
If these have a mistake in the 2061 of 2025.
What is the mistake?
The mistake is there is no file as such. The order which has been passed on 16 June.
16 June?
16 June 2025.
Yes, give this.
Only one difficulty, if your lordship do not grant leave, so that on the urgent basis, the department will not give the final number. The CO number will not given. The F number.
How can I give leave? That is also a problem.
Only for the purpose of release. Your lordship will make it clear in the at the time of releasing that in view of this urgency, your lordship. It leave
to file. Yes,
I'm grateful.
All right. I will see to this. Yes, call the next matter. Call them. Call the list.
Lord, I am for the petitioner.
Yes.
This matter is appearing for correction.
Correction? What is the error?
The year of the case number is written as 2025. That should be 2024.
24?
Yes, Lord.
Ashun, it has been pointed out that in the order dated 19th of June 2025, the year of the civil revision application was wrongly recorded as 2025 instead of 2024. First of, let such error be rectified. First of, this order shall form part of the order dated 19th of June 2025. এটা কি কারেকশন কষ্টটা কি ভালো কাজ
Lord, I am appealing for the petitioner, my lord.
Yes.
Today is for the extension of interim order, my lord. On the last occasion, on 3rd March 2000.
That is the affidavit service.
Yes, my lord. It has been served, my lord. Service has been effected, but it is yet to be affirmed, my lord. If your lordship.
It took time, 1 week's time to
Yes,
see affidavit of service.
Apology, my lord. Kindly make it pass over, my lord, in the due course of the day, my lord. Grateful.
Yes, next. Evening.
5, my lord, I appear for the petitioner.
5, you are appealing for the petitioner. Yes.
Extension of interim order.
Opposite party? Yes. Yes, Mr. Sen.
I am the plaintiff.
What is this? You are the plaintiff.
Yes.
What is the order impugned?
Lord, order impute is the, my lord, section 47 application has been rejected, my lord. One of the points taken in the section 47 application is that, my lord, the execution case is, my lord, proceeding against two dead persons. My lord, so far as there is no abatement, my lord, but the records are to be corrected, my lord, and the heirs are to be brought on record, my lord. That was not done. My lord, this is a partition suit, ex parte decree, preliminary decree, my lord, of
So
1980.
that cannot be a ground of 47. So I will give you liberty to apply for correction of
My
the-
lord, they have to take steps. They have to take
May I
steps.
pause here for a moment?
yes,
They have to take steps.
Well, I have already taken steps. After this order,
Right.
your lordship's order
yes.
of H5, I have filed the two applications for the substitution. Already filed. And because of this stay order, my lord, that matter was not taken up.
Stay of execution.
Stay order by
So now you have taken steps. I'm recording that.
Right.
Gautam Chakravarti.
Though this matter is appearing under the heading extension of interim order.
My lord, I am the petitioner, my lord. My lord, this is against an appellate order of injunction, my lord. My lord, in a suit for declaration and injunction under section 44 of the Transfer of Property Act, my lord. My lord, question is whether the property is a joint family property or not, my lord. That is, my lord, one Saroj Kumar Bandyopadhyay, my lord, he was,
What is the stage of the suit?
what is the state?
The courts have refused to pass an order of injunction. So unnecessarily keeping it pending here, I can direct the suit to be disposed of within a time frame.
Yes, the enter order sheet, my lord, your lordship, and enter order sheet of the trial court, my lord, I have annexed, my lord.
So what is the stage of the suit? I'm asking you.
My lord, your lordship, my lord. Enter, no? My lord, what has happened, my lord, after filing of the appeal, my lord, before the learned district judge record was called for from the learned lower appellate court. That is the stage where if you also can come to order number.
Now it has returned.
Not yet, my lord, not. Konta?
Oh, it has not yet returned.
But you'll also kindly see the order awaiting original record. Order number 29 dated 7th of March.
Has not been received.
Well, that is the.
I can direct the learned judge of the appellate court to send down the records, and I will direct the expeditious.
Logically considered, my lord, the case, my lord, logically, this is a 44, my lord. Yes, joint family property, my lord. One of the courts had transferred the property to a stranger. You will also clearly see the judgment of this honorable court, my lord. That even if stranger, my lord, he cannot be allowed to enter into the joint family possession, my lord.
Show me your plaint. Show me your plaint.
My lord, it will appear from the judgment of the learned appellate court, my lord. Judgment of the learned, my lord.
Please show me your plaint first.
My lord, I have annexed the order of application for injunction, my lord.
Plaint you have not annexed.
The injunction application of plain, my lord, more or less same, my lord.
House.
My lord, I am
All right. So
categorically stated, my lord, you must. Paragraph 10, my lord,
paragraph 10 of
the injunction application, my lord.
yes.
That the defendant number 1, my lord, is a stranger purchaser, my lord.
Yes.
It mentioned here the defendant number 1 after he purchased property measuring at such a from the
So this was a contested hearing or addendum.
No, my lord, contest.
Contested. Yes.
Kumar Bandyopadhyay by registered sale number such and such by showing false boundary.
So according to you, he is a stranger purchaser. He has no right to take possession,
Yes, my lord.
joint possession.
Yes.
And what is the case of the opposite party?
My lord, opposite party is that, my lord, it will appear from the learned lower appellate court judgment, my lord.
Yes, place that.
My lord, I am
Their case.
my lord, I am placing the order passed by the learned lower appellate court, my lord. Page 6 of the lower appellate court, my lord.
Yes.
My lord, first, second, third paragraph, my lord.
Yes.
The lower appellate court.
Yes.
Thus, prima facie, it appears that the family settlement being number such and such was never acted upon, and by the family settlement of the title of the resters cannot be taken away, and in that event the suit property remains a joint property of the family of the deceased Saroj Kumar Bandyopadhyay till now. Next. Now, with the application under Order 39, Rule 1 and 2, Review Section 151 of the plaintiff has paid for an order of injunction, restrain the defendant number 1 from taking joint possession in the schedule on the ground that the scheduled property is a joint dwelling house. Even in one petition was preferred, Order 39, Rule 7 was preferred, and the report of the learned commissioner is lying with the trial court. From the report of the learned commissioner, it appears that the only one PP and one bathroom in the suit property. But the case of the defendant, not any claim over the dwelling house. His case is that the plaintiff, the Dilip Kumar Bandyopadhyay has sold out 2 decimals of the vacant land to him, against which he has mutated his name in the records of the Revenue Authority, and a separate holding number of municipality also allocated. Record of rights is a document of possession from the sale deed. It appears that 2 decimals of vacant land at the north of the suit property has been sold, out of which specific demarcation. Boundary of the 2 decimals of property is
Sold in 2005. This was sold in 2005. And you filed the suit in 2021. Yes. Sale deed date is right, 2005.
Subject to correction, no, my lord. কতগুলো মেনশন করেছিল।
All right, you can proceed. Yes. Thereafter,
But in the plaint, it has been stated that the gift deed being number such and such. No, my lord, I purchased 2 decimals lamp from the Dilip Kumar Bandyopadhyay, Alice Banerjee. It appears from the recital portion of the deed, false averment made to the effect that the property was settled in favor of 4 sons as well as the mother, Kamala Bandyopadhyay. In the plaint, it has been stated that when the gift deed being number such and such was executed, share of the donors was shown as 1/5 each but it should be 1/7 each, and there are two other daughters of Dilip Kumar Bandyopadhyay and Banerjee, and it has been settled that subsequently Kalpana Bandyopadhyay has died in issueless condition, and thereafter his share never returned back. His share never returned back to the rest of the heirs of Saroj Kumar Bandyopadhyay, and in that case, surviving 6 heirs of Saroj Kumar Bandyopadhyay should get 1/42 portion of the suit property, even after disposing of the respective shares by Kamala Bandyopadhyay, Pinaki Bandyopadhyay, Banerjee, Swadesh Bandyopadhyay, Banerjee, and Swadesh. The prima facie it appears that the family settlement being number such and such was never acted upon, and the family settlement title of the rest heirs cannot be taken away, and in that way, suit property remains the joint property. My lord, I again repeating, my lord, I think that. Okay. Now, the application under Order 13, Rule 1 and 2, reduce section 151 of the plaintiff, he has paid for an order to restrain the dependent number 1 from taking joint possession in the schedule on the ground that the suit property is a joint dwelling house. Even one petition under Order 13 and Rule 7 was prepared, and the report of the learned commissioner is lying with the trial court. The report of the learned commissioner appears that there is only one TV and one bathroom in the suit property. But the case of the defendant not to claim any dwelling house, his case that the defendant defendant Dilip Kumar Bandyopadhyay alias Banerjee has sold out 2 decimals of the vacant land to him, against which he has mutated in the records of rights of the authority, and a separate holding municipality has been allotted. Record of rights is a document of possession from the sale deed number. It appears that 2 decimals of the land at the north of the suit property has been sold out with a specific demarcation. The boundary of the 2 decimals of the land is clearly mentioned in the deed, and it appears that the boundary that there is 3 feet wide lane and the south of the suit property, and the lane of Bhagavati Chatterjee is north. And from the report of the learned commissioner, it appears that there is a lane approximately 3 feet to the north of the house of the plaintiff, after which there is a vacant land enclosed 3.4 foot vacant wall. Thus, the report of the learned commissioner, it appears that after 3 feet wide, there is a vacant land north, as is shown in the sale deed of the defendant number 1. The vacant land cannot come under the definition of the dwelling house, and it's specifically separated from the house portion by a boundary wall of 3.4 foot. From the report of the learned commissioner, it clearly appears that the dwelling house is south of the 3 feet wide lane. In the case of description of the entire 6.5 decimals of the land of the suit plot as dwelling house appears to be erroneous. The defendant is not claiming any title over the house portion lying on the suit plot, but he claimed title possession over the 2 decimals of the vacant land on the suit plot. In view of the above, it appears that the court of the learned court has rightly rejected the prayer for temporary injunction, but the ground of rejection should be more clarified, in which this court makes it clear that the order of rejection of the prayer for temporary injunction would be applicable in respect of the house portion of the appellant and the pro forma respondent lying over the suit property, but would be applicable in respect of the vacant portion of the line at the not 3 feet wide or wide lane only. In the result, the misappeal fails. Now, Lordship kindly sees second part of section 44, my lord. My lord, it says other common or part enjoyment. If I'm a dwelling house and there is a appertaining land to the dwelling house, that comes within the definition of common enjoyment of the joint.
What were you doing from 2005 to 2021? What were you doing from 2005 to 2021?
My lord, your lordship kindly consider this Trespasser.
They are in possession since 2020, since 2005. Record of rights standing in their name.
My lord,
Separate Khotian has been opened in their name.
When they started the boundary wall, my lord, then they came to know, my lord. My lord,
2005, 2021 injunction.
well, in that event, my lord, your lordship kindly consider that in that event I have to take some instruction, my lord, because
What instructions?
my lord,
2005 is a registered deed.
my lord, when I came to know, my lord, for
Maybe.
declaration injunction, my lord,
Maybe, but they are in possession.
well,
They
limited.
are in possession. The record of rights in the
But in the vacant land, how can they be possession, my lord? Your lordship kindly consider.
record stands in their name.
Of rights, I have no access to the record of rights. I came to know when they started boundary wall. Your lordship kindly see the judgments. I shall show your lordship the judgments of this honorable court, my lord. They cannot, they should be taken out of possession of the joint family property. They cannot. When they started to erect boundary wall, then I came to know. Otherwise, my lord, I have no access to the record of rights. Vacant land.
Why? Why you have no access to the record of rights?
My lord, your lordship, my lord, I
That Cannot say that you are, you do not
I am not in
have access to the record, all right.
I am not in.
One of the co-sharers have transferred. Whether he had shared to that extent
There are
of
so many transfer among the
that,
co-sharers.
that portion that has to be decided at the time of trial. Your contention was that this Dilip Bandyopadhyay
Injunction is concerned. Well, the other, that is, that land is now part enjoyment of the joint family property. Well, they cannot, my lord, under section 44, second part of section 44, my lord, standing in the way, my lord. My lord, you also can allow me to place judgment, my lord, your lordship.
I have to, I cannot, both the courts have refused. I can direct you to sir.
See, the lower appellate court has clearly held that it is a joint family property. It is a joint family property. There is dwelling house and there is a land, and they cannot claim any right over the joint family property. Only the land, which is appertaining to my joint family, to my dwelling house. But that is my part enjoyment of my dwelling house. But they cannot. That is a section 44, second part of section 44, my lord.
All right, show me the judgments which are trying to show.
My lord, first judgment, I am sure I shall show two judgments of your lord, of this court, my lord. AIR 1992, volume 44, my lord. This is a judgment of Justice A.K. Nondi.
AIR 1992?
82, my lord, 1992. 92.
Yes, 1992.
92, volume 0, page 44.
Calcutta, AIR 92 Calcutta.
Yes, my lord, Calcutta.
Page
44.
44, yes. Yes, please.
My lord, shall I hand over, my lord? Shall I hand over? Paragraph 6, my lord.
Paragraph 6.
Paragraph 6. Now, what are the issues?
Yes.
My lord, another judgment, my lord, I am sorry. That is AIR Calcutta 2004, volume 0, page 170.
2004 Calcutta, page
170, my lord.
paragraph.
My lord, paragraph 8. That is it.
Have you brought AIR 1990 Supreme Court?
1990. My lord. No, my lord.
Page 867. That's the parent judgment on section 44. Last paragraph, how it should be dealt with, it has been said. You have not brought that. That's the parent judgment.
But that was relied upon. I think so. That was relied upon. Yes.
That's
That
should have
was it.
brought that.
My lord, both
That's
the
the
court,
parent judgment. In all judgments of section 44, you will find that judgment is being relied upon. Yes, anything more?
my lord. My lord, only one thing, your lordship, perhaps my lord, 1990 Supreme Court, my lord, that has been relied upon by Justice A.K. Nandi, my lord.
All judgments of section
my lord.
44.
On the basis of that judgment, my lord, his lordship has passed this judgment, my lord.
That is why I asked you, have you brought that?
My lord, since it has been mentioned, my lord, in the body, in both the judgments, my lord, which I have brought before the lordship.
Anything more?
My lord, my respectful submission before your lordship, my lord, they cannot be taken possession of the joint family property. My lord, that is has been held by our High Court and also by the Supreme Court, my lord.
Ashun. This application under Article 220
couldn't go into the link.
It's a matter of trial.
And another thing, my lord, I cannot go to trial, my lord.
Yes,
My lord, no, prima facie
I've said prima facie. I did not want to make these observations. You have invited. I was only saying I will expedite the suit. When I have to decide on that.
my lord, your lordship,
I only said prima facie. I have not said prima facie.
kindly
I have not said you cannot go to trial. I have said prima facie case to go for trial because those are the ingredients.
kindly observe
If
that.
I hold that you have made out a prima facie case, then you are
My
entitled to
lord,
it.
my lord is absolutely right, my lord. My lord, to clear, my lord. Your lordship, kindly observe that your lordship has not gone into the merits of the case, my lord.
So prima facie,
My lord, your lordship, kindly
that I will
observe, my
do.
lord, that will have some.
I'm expediting the suit that I have said at the beginning.
My lord, that too, and your lordship has not gone into the merits of the.
What? Injunction I had gone into.
Of the suit, my lord.
Suit I cannot. I have said prima facie
My lord, kindly, my lord, that will have some impact upon the landed trial court, my lord.
cannot be.
My lord, your lordship, kindly consider, my
So
lord.
it cannot be. Injunction, hearing, and suit, trial. That is why I have said this cannot be decided at this stage. It's a matter of trial. I've made it clear there.
Your lordship, your lordship's observation, my lord, will have some impact upon the landed trial.
Full stop paragraph. After an application can the dispose of main matter চলে গেছে can কি হবে disposed of accordingly. সৌরভ সেন. Yes.
My lord, in item number 7, I am appearing on behalf of Mr. Kamlesh Chandra Shah, sir. The senior advocate is engaged in due to
Engaged where due to evidence
in nearby airport area, sir. So
airport area.
yes, sir. Kindly not today.
I believe a caveat is also pending, Millard. If they can serve us, Millard, a caveat was filed in April, Millard.
Please
Yes,
serve
Millard.
advocate for KB.
Let them serve, Millard, we will come back. Grateful, Millard.
আসুন yes next
Lordship, this is my application. Lordship, this is a case and motor accident claim case in which the claimant
You are appearing.
have the instruction to appear on behalf of the claimants. Let him serve a copy of this application.
You have lodged any caveat.
I have not.
Please take your seat. Do you have a chair behind you?
I'm giving the shoot.
Yes, yes. Yes. Yes, Mr.
Lordship, this is a claim case in which the claimant has claimed around 1 crore 28 lakhs from the insurance company. Your Lordship, the dispute in which arises, there are two applications which have been filed by the respondent number 2, the petitioner herein, the insurance company. Your Lordship, kindly come to the ordering.
What are the applications for?
The two applications. One application is under Order 26, Rule 9, in which
For what?
we
You have
have,
motor accident claim?
Your Lordship, Lordship, in which we have.
I think I'm hearing this for the first time.
Yes, Your
Have you
Lordship.
come across earlier, Order 26, Rule 9, in a motor accident case?
No, Your Lordship, I haven't.
For myself, I can speak for myself. I am hearing it for the first time.
For me, it's also for the first time.
Thank you.
Your Lordship,
Yes. So that's the ground for rejection.
Lordship,
That itself is the ground for
whatever
rejection.
falls from Lordship, I bow down, but Your Lordship, kindly let me submit for 1 minute, Your Lordship. In Order 26, Rule 9, the contention of the insurance
Where
company.
is your application? Please
Yes,
come to the application straight away.
Lordship, this application is not annexed. I have obtained a certified copy.
Yes, give
Your
me the
Lordship.
copy of the application.
Yes, Lordship. Devan, Lordship. Both the applications are annexed one by one, Your Lordship. Your Lordship, kindly come firstly to the Order 26. The insurance company's contention is they want an inspection of the shop room. Here, the claimant, the deceased, is a partner of a mobile shop. Your Lordship, it's a partnership firm. Now, Your Lordship is well
What
aware.
will do by local investigation?
Let me elaborate. Your Lordship, the claim, whatever the claim has been lodged by the claimant, is due to the loss of income, Your Lordship. Now, as this is a partnership firm, we have to find out whether there is a loss of income actually is happening or not, because it's a partnership firm.
How can that be decided by local investigation?
Now, we haven't got hold of any documents of the
The commissioner will go documents. Yes. What is the other application?
Your Lordship, the other application is on Order 16, Rule 14, Your Lordship, in which we have requested the learned court on for giving us a chance to give a cross-examine the investigating officer of this case, of the police.
Investigating officer of
The police.
what case?
Police. There's an accident happened, Your Lordship.
Yes.
So there is the FIR has been lodged.
The criminal case is pending.
The criminal case has maybe
Satisfied with
has been given.
So yes. If you are not satisfied with the investigation there, next steps there.
No, we just want to get an option so that all the criminal
Satisfied with the investigation.
not there are certain grounds. Your Lordship, kindly come to my application to that. It's the next. It's also annexed with my. Lordship, kindly come to this petition, Your Lordship. Kindly come.
Where is that?
After that, Your Lordship, or it is annexed as Annexure A. Annexure A to the civil revision, Your Lordship. On para 3, we have categorically showed for what reason we are asking the police authority, the IO, to be present.
Yes, Order 16, Rule 14. Yes.
Yes, it's para 3, Your Lordship. Para 3, in wherein we have elaborated each and every points in why we are requesting the learned court for the evidence of the investigating officer, Your Lordship. Your Lordship, that should be allowed, Your Lordship. At least for the sake of justice, that should be allowed. I bow down that my Order 26 should be rejected, but this should be given a fair chance, because in most of the cases wherein a substantial amount is involved, the IO needs to be cross-examined, Your Lordship. And nothing more. And that could be done on a one-day basis. We will not take any adjournments, we will not do anything, Your Lordship.
Where is your objection to the claim application?
Claim or my written statement.
Yes.
Just a minute, Your Lordship.
Is it in this bunch?
No, Your Lordship, maybe not. I'm just finding if I have a copy of it. I have the entire set of cross-examination certified copy.
The written statement,
No, no, Lordship, it's not readily available with me. Your Lordship, Lordship, this should be the copy of the written statement. This should be the copy of the written statement.
yes, your case is that you have denied that a criminal case has been registered. That's your case in the written objection.
Yes, Lordship. The Lordship, one chance to be given in one day will come.
Nothing much. This application under Article 227 of the Constitution of India is at the instance of the
Your Lordship, the just one submission, the petitioner wants to derive that whether the contributory negligence are there on the part, that one liner if could be.
Yes, next.
9, my lord, I am appearing for the petitioner. My lord, I am assailing, my lord, impugned orders passed by the, my lord, District Consumer Redressal Forum, South Chubbish Pargana, situated at Baruipur.
Yes, there's the provision of appeal.
No, my lord, I am not assailing, my lord, my lord, it is situated at Baruipur.
Yes,
If I am be allowed to,
that is for you to say whether I can take up or not.
yes, my lord. But if my lord allow me, then I can.
Yes, but
I
there's
am
a
not-
provision of appeal.
Yes, my lord. I am not, my lord, assailing here the order passed in the consumer case. But my lord, I am assailing here the order passed in a pending execution case, which is an interlocutory order, and there is no provision of
Interlocutory-
appeal.
There is no provision of appeal. So be the Consumer Protection Act. There is no provision of appeal.
Well, it is an interlocutory order, my lord, passed in pending execution case. Kindly see. There may be
Which section?
section, perhaps, my lord, revision of, there is a statutory remedy of, my lord, revision. But my lord, alternative remedy is not an absolute bar when the order is, my lord, without any jurisdiction or without sanction of the law.
When the statute provides for a revision, this is also revision.
No, my lord,
Why
there-
should not avail of
my
that
lord, no,
revision?
there is catena of judgments, my lord. The judgment
Where?
of the coordinate bench, here and now I can show, my lord.
Supreme Court,
Yes,
what does the Supreme Court say?
the Supreme Court says, my lord, alternative remedy, not an absolute bar in case of my
But the Supreme Court has deprecated the practice of interfering in consumer protection matters,
yes, my lord.
bypassing, bring that judgment of the Supreme
If,
Court.
my lord, I am satisfied, I am able to satisfy, my lord, that the order passed by the, my lord, consumer forum is in excess of his jurisdiction. Because, my lord, to
Yes,
execute
which provision provides this revision?
revision, my lord, in earlier act, my lord, perhaps it 21 to 2019 is there, my lord, book. Only one book, my lord. Order passed under new act, my lord, 2019.
Yes, what is the infirmity according to you?
Infirmity, my lord, the consumer protection, the consumer forum, my lord, in the execution case, passed an impugned order of arrest of warrant to execute its order. That is the, my lord, my point of, my lord, points of law. It is, my lord, if my lord kindly come to, first of all, my lord, the consumer case has been disposed of and passed the alleged order, which I am not challenging herein. I will challenge in the same in the appeal. But my lord, the same was passed, my lord, without serving any copy to me, and it was an expediting order. Now, my lord, the opposite party did what, my lord, filed an execution case without any service. Now, my lord, the consumer new act of the Consumer Act, section 71 and 72 deals with the enforcement of the orders.
Which order you are challenging?
Well, I am challenging, my lord, last annexed 3 orders, my lord. Kindly
Yes,
see.
yes. Which are
Certified copy I have annexed, my lord. Order
Yes.
dated 24th April. Next, my lord, order dated
24th of April 2025.
2025.
Give me a minute.
May I read, my lord?
No. Please give me a minute.
Due to defective procedure, my lord, the warrant returned. Again, it is reissued.
Why are you not appearing before the?
Yes, my lord, I have appeared. Kindly see my last order, my last order, my lord. Kindly see. Order dated, my lord, 5th of June. The learned advocate for the judgment data, number 1, prays for time to comply with the final order passed in such and such. Even though, my lord, the order of warrant of arrest has been issued.
So you will comply. So comply with that. I'm recording, file an
No,
affidavit.
my lord, do not do that, my lord, because
Why?
my lord, I have a.
You said
My-
it's your submission.
Yes, my
Judgment
lord.
data prays for time to comply with the final order.
But my lord, kindly consider, my lord, I have a also statutory right to appeal, my lord.
Go there, challenge
Has not
everything.
been, my lord.
Go there, challenge everything. Sir, you have said you have one time to comply. That's your submission.
Create for times.
Yes,
my lord.
comply.
And also for necessary instruction.
No. To comply with this.
Understand, my lord. But my lord, I am against my lord issue of warrant of arrest. Because my lord,
This is a money decree.
money degree.
Secure that amount. Deposit that amount. I will allow you.
Definitely, my lord, in due course. But my lord, the question is that whether a consumer
Sir, as a condition of stay, please deposit that amount in the court. I will grant you stay.
in that case, well, I do not have an instruction like that, my lord. But
Sir, you may or you may not have money degree staring at your face. You have not challenged that decree.
But I will challenge. I have stated in my petition, my lord.
So do that.
Because, my lord, the decree has been passed, my lord. The order has been passed by expedity without serving.
So you have
me.
if an order is passed ex parte,
Kindly consider that.
sir, even if an order is passed ex parte, you have a remedy by way of an appeal.
Then, my lord.
So this order was passed when
My lord, impugned order
was passed 23rd of August 2024.
No, we-
And in the execution application, you took time to comply with that same.
Yes,
Now you are coming up challenging that and you are saying you are contemplating to prepare an appeal.
in the same, kindly consider my submission, which I have stated on oath that the order has been passed expedity without proper service to me.
All right, sir.
I
Even if,
also have, my lord.
sir, what is the law? If there is a money decree, stay, you have to secure. Good, bad, indifferent. You don't have to pay to them. Secure, show your bona fide, deposit in
my kindly
as a condition for stay. Court can pass that order.
Then, my lord, kindly consider, subject to my lord's consideration.
I
kindly pass an order that I will secure the money at the state commission before preferring the appeal, my lord. I will definitely.
I will not stay. As a condition of stay, you have to deposit first. I will pass an order of stay then. That's the condition.
Full amount, my lord. 2,23,000.
Yes. That's the law. That's the law.
Or consider I have right to appeal, my lord. There also I have to, my lord, pay 50%, my lord. I will definitely pay.
No, if you
State commission.
Sir, if you secure the entire amount, you need not to pay an addition. Or you can prefer an appeal there. Do everything.
I will definitely in due course, my lord.
Obtain an order of stay there. You need not deposit here anything. You can only deposit 50% there. That's the choice.
But my lord,
227.
arrest of warrant is, my lord.
Sir, yes.
But because it is
That is
passed
why.
without jurisdiction, kindly consider that
Sir, that is why you have paid for time to comply. This is your admission that you will comply.
kindly record this, that in the commission I have paid time to comply, my lord. Kindly record it.
Yes.
But my lord, kindly, my lord, stay the execution order.
Yes, subject to deposit of this. Execution can be stayed subject to the deposit because 227 code, it's not bound by the statute also. 227 code can impose conditions. That's the risk. You are taking
is a huge amount for my client, my lord. Kindly.
Sir, money decree.
And presently, I do not have any.
Money decree, that's the provision of the Civil Procedure Code.
If I cannot satisfy my lord, then my lord.
These are the provisions of the Civil Procedure Code. Kindly come to Order 41. Money decree.
Yes, my lord, but my lord, the statute says, my lord, order 21, that has to be followed, my lord, by the commission in case of, my lord, passing the enforcement of.
Sir, you contemplate to prefer an appeal. So please prefer an appeal. Why are you delaying in that?
My lord,
where you can operate.
At a later stage, my lord, I received this information that an warrant of arrest has been issued. My lord, then I came before this court. I will in due course will prefer. My lord, kindly recommend me,
sir?
Within my lord, 1 month.
Within 1 month? Why?
Because, my lord, I do not have the information. I have
what information? What information? Certified you have filed this application.
Certified petition I do not have. I do not have
petition.
But petition of the complaint case and others, my lord. I have to obtain the certificate.
Where if you want to stay, you have to deposit the entire money.
Entire money, my lord.
Please take instructions. Yes.
My lord, kindly entire money.
Yes, that's the
huge
law.
Money, my lord. 2 lakh.
You can put in conditions. You are not paying to the other side. You are only depositing here. So who are you? You are a
But I am the, my lord,
financer.
opposite, no, I am the opposite party shop owners, my lord. I sold,
No, what is the dispute?
my lord, defective, my lord, machine as per their version, defective machine
All right.
for
So,
deficiency of service,
So you are a manufacturer of machines.
not manufacturer, but seller. Seller
Dealer.
of the, yes, my lord.
All right. So you secure that amount.
I tried, my lord, many times.
By way of a bank guarantee also you could. By way of a bank guarantee also you can do. But you have to secure the amount.
Then, my
By
lord,
whatever
kindly pass
mode.
it over. I have to take instruction, my lord, kindly for a time being, my lord.
Stay without condition, money decree cannot be done. That's the law. That's the law. And under the in the appeal, what you have to do? There is a pre-deposit also in the appeal.
In the appeal, my lord, by
For stay, there is a pre-deposit also. Where is that? Which provision?
appeal provision.
Appeal provision, is there any provision for pre-deposit?
50% of the, my lord,
Where is that provision?
I have only one book, my lord.
Oh, you have only one book. Yes. If you want, I can give you time to take instructions. You don't have to pay to them, but you have to deposit in.
By bank guarantee.
Bank guarantee, money that will be invested. Need not have to be worried. Invested in
Payment-
short term,
Then, my lord, the
fixed
payment may
deposits.
be, the payment may be, my lord, realized, my lord, maybe, my lord, realized, subject to, my lord, appeal, my lord, subject to result of the appeal, if any preferred by.
Payment not asking you to pay to them.
Yes, yes.
I'm saying that you have to deposit it. That will be invested in short-term fixed deposits in a nationalized bank, fetching interest. If you win, you will get that amount together with interest. And if you lose, they will get that together with interest. That's the security. Yes, you can take instructions and then
I have to
come.
take instruction. Kindly pass it over, my lord. In that case, my lord.
Pass over. Yes, call the next matter. Yes, Mr. Ganguly, another local investigation.
No. This time it's the OPW has been closed, Your Lordship.
PW closed.
Closed, Your
Why?
Lordship. Due to my mistake, Your
So
Lordship.
if OPW has been closed, you apply for recalling of OPW.
I've done, that has been rejected.
That has been rejected.
That's why I'm before Your Lordship.
Where is that application? Show me
So,
your application.
Application is, kindly come to first the ordering portion, order 55.
So show me the application first. Let me see what is the ground you have cited there.
Only of one pager document, Your Lordship. Kindly come to page number, page annexure A, page 10, running page 10.
10.
Yes, Your Lordship.
It's big defense case. What is that document?
Your Lordship, I'm submitting. It's the video recording and the audio recording which has been, we have done it.
No, you have not disclosed that, Mr. Ganguly.
Yes, we have not-
Nothing you have disclosed.
That's the issue.
So,
Your Lordship, just one fair chance to be, I'm admitting my mistake. I'm admitting that there is
what do you want?
just an OPW to be done.
No. To produce only one document. What is the nature of the document and what does it have in relation to your defense case? Show me your defense.
Yes,
How
Your-
is it related?
Your
That
Lordship,
document
kindly-
is related to your defense
Yes, Your
case.
Lordship. Your Lordship, this is an accident case
Yes.
in which we have to prove that whether the accident has been correctly been happened with the victim or not, or whether the insured card is involved in that or not, so that we can pay the claim. Now, if Your Lordship is well aware, if the card is involved and if the insured card is not involved, then we are not liable to pay, and whoever is it may shift. Burden may be shift to the owner of the vehicle, Your Lordship. So now Your Lordship will find out we have got hold that this vehicle has been implanted. This vehicle, which is the insured vehicle, is not it's a hit and run case, wherein from the inquest report and from the other documents, it has been found out by our local investigation team. It's found out that is a hit and run case wherein the car number is not being specified. It has been implanted after some time later, and we have investigated and we have got hold of certain video recordings and audio recordings of the claimant side, which proves that. And for that, we have sent that to the forensic expert as well. And we have obtained the forensic report, which we got hold of around 7/10/24. And that is
7/10/2024.
7/10/24, there has been issued, and then
That is after this application. That is after the earlier application was filed.
there are two investigations, two reports.
No, these reports which you now want to produce by
Yes.
way of an evidence,
Yes,
this was obtained after the application was filed.
yes, Your Lordship.
So
But
this could not have been the ground.
no, Your Lordship, we are aware that we are going out with the investigations. We are not hold because we haven't reached.
So
We have given that
So you
report.
file an application to that effect. These are the documents which you have obtained after
Okay.
that.
I'm
So this application does not state anything. So you'll be at
Your Lordship,
liberty.
kindly give me a liberty. Yes, I will do that. If trial court is satisfied, then only it will be.
What happened on 18th of June 2025? It was for argument.
Argument doesn't happen. It's fixed today for again argument. Today it's fixed before the landed trial court for argument. I'm well aware of the facts.
So please come tomorrow then.
Lordship, I have taken.
You file an application today itself stating this. Let me see what happens.
Your Lordship,
Please file an application today itself.
it's not possible because
Why?
the office is in Kolkata and the matter is in Durgapur, if I'm not wrong. So the officer
I
has
cannot
to
say that in so many words. Purposely, I'm keeping it for tomorrow. Now it's for you to decide how to manage.
So Your Lordship, just not today,
I'm making it not today only.
Your Lordship. But the application couldn't be done. I'm submitting candidly, Your Lordship. The application couldn't be done. I'm understanding. I'm just paying I have
But
already.
I've lost that capacity now. I cannot say that here. You have to advise your client how to do, what to do. Yes, call the next matter.
Okay.
Article 11, I am for the petition, my lord. Plenty petition before your lordship, my lord. My lord, I am the landless person, my lord. The government has been granted patta in favor of me, my lord. Now, my lord, the opposite party, my lord, tried to dispose me, my lord. Then, my lord, I have filed one suit before the landed civil judge junior division. Initially, my lord, I have got an order of injunction, my lord, restraining them not to dispose me from my property, my lord.
Now you have been dispossessed.
No, my lord. What
You have
happened?
not been dispossessed.
My lord, what happened, my lord? My lord?
Still you are there.
But symbolically and physically, I am there.
Symbolically.
And physically, both the way I am there.
Yes.
Now, my lord, despite of that, my lord, but what happened, my lord? They are creating, my lord, certain circumstances, my lord, which, my lord, entails me, my lord, from disposition, for disposition. Then and there, my lord, for the implementation of the injunction order, my lord, I have filed an application for implementation.
What happened to the injunction is the ad interim order.
Ad interim.
So ad interim order can be
Extended time to time, my lord, it has been extended.
in
As
that-
they have not appeared, my lord, it has been extended.
Yes.
Still, they are not
When
appeared.
did you file this application under 151 for police help?
My lord,
After the ad interim order was extended in their presence or before that?
but before.
Before that.
Before.
So you wanted to implement ad interim order of injunction.
Injunction. Still,
Still, there are provisions that an ad interim order of injunction can be implemented by police help. Show me.
well, only by 151, my lord.
Show me. Show me. Yes, 151.
151, my lord, only, my lord.
Show me that an ad interim order of injunction, ex parte ad interim order of injunction can be implemented by police help. Show me.
But only 151, my lord, there is no provision, my lord. Only by 151.
I'm saying 151. Show me.
But inherent power, by using the inherent power for the ends of justice, my lord.
But I know 151 is inherent power. That much I know. So I'm asking you to satisfy me that under section 151, police help can be granted to implement an ex parte ad interim order of injunction. Satisfy me.
Order of injunction, my lord, can be, my lord, ex parte, my lord, some judgments are there, my lord. I have to take that judgment, my lord. Then I
Please
have
bring those judgments.
but then
Please bring those judgments. And what are the guiding principles for deciding an application under section 151 for police help for implementation of an order of injunction?
my lord, restraining them.
Please also bring those line of decisions.
My lord, in the nature, my lord, restraining them, my lord. It is not a
Sir, I know. I'm asking you. Because I'm not aware of those provisions of those
my lord,
decisions
my lord, no,
which,
my lord.
which
But
allow
despite of that, my lord,
that is why I want to see those line of
then, my lord,
decisions.
I shall satisfy, keep it on Monday, my lord. I shall give some judgment, my lord. I shall
Please
bring
bring
some
those
judgment.
line of
Yes,
decisions,
yes, yes, my lord. Definitely.
where how to be decided this type of applications,
Yes, yes,
151,
my lord.
and ad interim order of injunction can be implemented. Please bring all those.
By this court, I think, my lord.
This court, Supreme Court, whatever, because I'm not aware of those.
Yes, yes.
Please bring those judgments.
Monday.
Ashun, after some argument, the learned advocate appearing for the
of July. I have reconfirmed from the
11th of July.
Yes. So order could be passed, whatever falls from your lordship. If order could be passed, your lordship,
For what?
whatever falls from your lordship, though, as your lordship said, it isn't today, so I'm making it not today.
Yes.
So has it not been fixed today? It's in 11th July. Your lordship, whatever falls from your lordship,
Today we are 8th.
8th. So it's in 11th.
So I'm keeping it in the next week. Please apply your mind, what to be done, do that. Okay.
Because
What was your item?
10. Because the application, because the court will not consider, the argument will be heard. That's why I want to be forward. If your lordship give me a fair.
Right. Yes, call the next matter.
Yes, my lord. Now the petitioner.
Yes. Yes.
Present application has been filed challenging the order number 59 dated 7th May 2025 passed by Civil Judge Junior Division Barrackpur number 1 court entitled suit number 255 of 2011 for making a certified copy of registered deed of gift 2646 of 2012 as an exhibit was erroneously rejected. I have filed an application under section 151 to exhibit the document which I have relied. The thing is that I do not have the original copy of deed which I am relying upon the
You don't have the original copy of the deed.
original.
Show me your evidence. Where have you stated? Foundational facts for leading secondary evidence. Show me that evidence. You are the plaintiff.
I'm the plaintiff, my lord. It was a suit for eviction.
All right, show me that you don't have the original copy. Where have you stated?
So I have stated in the trial court that I don't have in the original copy in my custody.
Where is that? Show me in the evidence.
Order page 30. My lord, page 30 to 37.
Page
30 to 37.
37.
30. Page 30.
Page 30.
Page 30. Running page 30 to 37. Where
Yes.
I have filed affidavit in chief.
Yes. Where have you stated that you don't have the copy of the original? Show me that paragraph.
My lord, I have not stated specifically. Even I have not stated specifically.
Then
My lord, it was noted in the ordained portion that I was not in a position to file original copy.
why? No, show me from the evidence.
I do not have, my lord.
Sir, 65
C.
65C.
65. My lord, the Garnet code below FL order 65 group A, my lord. Wherein this certified, I have relied certified copy of the deed is a public document, my lord. And
Certified copy is a secondary evidence.
yes, my lord.
So it's a secondary evidence under section 63.
Yeah.
Please kindly come to section 63. So the 65 conditions are to be satisfied for leading secondary evidence. So your case falls under 65C. You have to fall under any one of the subclauses of section 65. Show me which have been satisfied.
Now I am coming to the clause number E 65E. When the public document E 65E.
Yes.
I have relied on the document which is certified in nature, certified copy, which comes when the original is a public document within the meaning of a.
It's not a public document, sir. Gift deed is not the public document. No, sir.
My lord, if
There are some judgments, I'm telling you, there are some judgments which says sale deeds, gift deeds are public documents, but those are under land acquisition cases for the purpose of proving the valuation. But gift deed, sale deed, these are purely private documents, not public
my
documents.
lord,
Private documents kept in the public custody.
my lord, I'm
That's
coming to
it.
that point.
So
My lord,
it's
I
not
filed
that,
this suit for eviction of licensee.
sir, maybe
I do not have, it's honest confession, my lord, I do not have any copy of
Sir, you-
it.
sir,
Now,
merely by saying, please kindly come to 65C. Secondary evidence may be given of the existence condition in the following cases. Unless you satisfy 65C, you cannot be allowed to produce that secondary evidence. That's the law.
okay. My lord, I am coming to the judgment passed by Honorable Justice Ajay Kumar Mukherjee in the year 2024. It was reported in ICC case.
Yes, show me.
Now, wherein Honorable Justice says Evidence Act 1872, Section 64 and
Please
65.
give me the decision. Which paragraph you are relying upon?
6 to 17.
16 and 17.
Tarana.
আসুন।
My lord, in cross-examination, my lord, I have voluntarily submitted that the deed is at schedule of page number 35.
35.
35.
Yes.
Just because it's a suit for eviction of licensee and the recovery of possession, the title deed, which is the subject matter of this application, is lying in that suit property, and I'm outside the suit property. So it is not possible to bring the original one.
Where you have stated?
My lord, for the
I've
cross-examination,
not
I have
filed.
filed the certified copy of deed being number
It is 35.
page number 35.
Yes. I have filed the certified copy. Presently, the original is not in my custody.
Custody. And then said, I have not informed the court that I do not have the custody of the original deed with me.
But the next sentence,
Yes.
where you have said that the presently the original deed is not in my custody, the next sentence is very damaging.
Very
You have
damaging.
volunteered,
Yes, my lord.
then
That's the
deed
case.
is at the scheduled property. So there is
My lord.
existence of the
Yes, my-
original document.
The learned court can take that objection on the stage of argument. On the stage of argument. But my lord, without giving opportunity to exhibit the document, how can I prove my ownership, my lord? The suit will become infractious, my lord. At this stage, then opportunity may be
By
given.
the order impugned, Thank you. Yes, call the next matter. Listed application.
Humbly, my lord, I beg to appear on behalf of the petitioner, my lord.
Item number 13.
Lordship. With your lordship's leave, my lord, I beg to move this application for expeditious disposal, my lord,
What?
of one title suit, my lord, 1350 23, my lord, pending before civil judge, senior division 7th court at Alipur, my lord. The only reason being, my lord, the ad interim order of injunction was passed, my lord, on 13th August 2023, my lord. Till then, my lord, it has been extended, my lord. And my lord, order 7 rule 11 application is also filed, my lord, on 7th March 2024, most humbly, my lord. That is also pending, my lord, till date, my lord, and not heard, has been heard, my lord. 7th March 2024, my
The
lord.
suit cannot be expedited because the service is not complete. Service returns.
Lordship, application, my lord, order 7 rule 11, my lord, the application has been filed, my lord.
This application under Article 227 of the Constitution of India is at the instance of the
No.
Item number 14, I appear for the petitioner.
Yes.
If this is an expeditious disposal of a consumer complaint pending before the State Commission, but the matter is pending for final hearing. Now, if your lordships comes to page 18 once. Now, page 18 on 17th of March 2023.
14th of July, 24th of July, it is pending for
Pending.
final hearing.
Page 18.
For argument.
Page 18, 17th.
Yes.
It is hanging for.
Nothing. Disposed of. Yes, next. Disposed of the bolechi, CO number certain service. Yes. Yes. Yes, Mr. Rai.
In this plaintiff is the petitioner before your lordship, and you turn to page 28. The suit was filed for eviction of a trespasser on the ground 2G. Kindly turn to page 28. application under section.
Why have you not come to court?
Well, I mean, totally surrounded by water. I mean, like I'm feeling, my lord, lotus surrounded by water.
Yes, yes.
Can you turn to page 28?
28. What happened in 28?
Where under section 7.1, though it is not a suit under the section 6 of the Premises Act, but be as it may, he filed an application. Page 28.
Yes,
Prayer.
Mr. Rai, that's pending for hearing. You take all points, it's not maintainable.
Disposed of.
7-2 disposed of.
7.1 disposed of. This is an application made under section 7.1. Page 27. Next B.
This is a suit under 2G.
2G. For this, though not admitting, assuming, my lord, this is a suit under the section 6 of the Specific Act. Then also under section 7.1, this application can be, this order can be, application can be allowed or not. Can you consider in that way also?
What happened? Which order you are challenging?
Order number 22nd, May 2025. 7.1 allowed, hearing of 7.2. Without giving opportunity of hearing, nothing to that extent, 7.1 allowed. Then, my lord, what is the use of March and April by single deposit?
What is,
appears
Mr. Rai, what is the difficulty? They will not get the benefit, so they will get the money, Mr. Rai.
I don't want, my lord. I don't want. I am quite happy with what I have. My lord, colleague. Otherwise, it will create a subsequent problem.
Let that be deposited. If you don't want, you can donate that amount.
My lord, colleague, even assuming, my lord, this is a suit under section 6, whether this prayer can be allowed under 67.1, my lord, if you lordship record that, this prayer can be allowed under 67.1, I'm out of court. 7.1, my lord, can you consider?
Now, what will happen, Mr. Rai? It's the next date, 4th of July, is for hearing of 7.2. I can,
Don't
Mr.
be hard, my lord. I am ready to take the consequences. My lord, I bow down to your lordship.
Mr. Rai, I can do one thing. Please apply your mind. I can give you liberty to raise all points in 7.2. Otherwise, they have to come. In the meantime, nobody knows what will happen.
Precisely, my instruction was that, my lord, because there is no chance of hearing in recent time. The otherwise, I will advise my client not to place this application and go for hearing. But there is some reason due to, my lord, I cannot express anything before the court. My lord knows very well what are the reasons.
All right. There is substance.
No. Admit, state. তো ওটা লাস্টে কি বলবে সেটা তো চললো না
Yes. Call the next matter.
My lord, my application, my lord.
Yes.
This is application for, before your lordship, for expeditious disposal of one Misc case.
Of a Misc case.
Miscellaneous case, my
Misc
lord.
case under what provision?
Order 9, Rule 13, my lords, I obtained a decree. Actually, my lord, I filed a suit for eviction. The defendant appeared, my lord, but did not continue. I obtained the ex parte decree. They have again filed in 913 along with section 5. My lord, this section 5 is pending since 2022.
Section 5 has not yet been disposed of.
No, my lord.
This application under Article 227 of the Constitution.
This is your lordship. I have got the petition on your lordship. But I have there is a caveat in this matter. I have served the
My lord,
opposite party.
I
My lord,
appear for opposite party number 1, my lord. I beg to appear.
Yes, yes.
My lord, I'm challenging the order. I mean the appeal court's order, my lord, at page 85 and 89. My lord, may I indicate, if your lordship permits, the fact it's a very much important.
Impugned order.
My lord, page 89 and page 85. Both the orders are impugned, your lordship. May I indicate? My lord, but before this, lordship, I'll have to indicate, your lordship, the fact. My lord, to enter cases based on the facts, your lordship. And all are narrated by the, I mean, all are categorically decided by the trial court while adjudicating or rejecting their application section 913. Lordship, my lord, may I put the fact first? My lord, I have filed a eviction suit, your lordship. Opposite party filed a written statement, but no step was taken by them till the date of ex parte, your lordship. Now, my lord, what happened in the interregnum? My lord, an application was civil revision filed before this honorable court, challenging the order of the trial court. While in my lord, challenging the order of the trial court, where trial court allow me to file an affidavit in chief by not pressing the earlier one. Well, in that order was challenged before this honorable court, your lordship, the coordinate bench stay the entire proceedings, your lordship. My lord, the order was in page.
What happened after that?
My lord, stay was there. My lord, a specific direction was passed to the court that a stay of that particular suit to the comply to the particular fourth bench of the trial court, your lordship. And my lord, after that, no step was taken by them. Civil revision was dismissed for default. According to them, they have filed an application for restoration, but no order, nothing has been till on surface, your lordship. Now, my lord, in the meantime, your lordship, they filed section, and my lord, thereafter, my lord, ex parte judgment has been passed, your lordship. They filed section 913, your lordship. In section 913, your lordship, they have stated some facts. contradictory, and that is also from the record available, Your Lordship, that before the trial court. Trial court categorically recorded all the facts, Your Lordship, their submissions, and our submissions on the records available in the facts available in the record, Your Lordship, and reject their application.
Order 9 Rule 13 dismissed.
Dismissed.
So
And
there was a section 5.
Section that was
Section 5 was dismissed, or
Yes, Your
section 5 allowed, Order 9 Rule 13 dismissed.
both are dismissed, Your Lordship. Both are because 200.
Thereafter, they preferred a miscellaneous appeal.
Appeal was preferred, Your Lordship, and appeal court, Your Lordship, itself recorded that the case of the opposite party was frivolous and baseless, and just because of granting, just because of give them a chance to contest the suit, direct them to pay 20,000 20,000 cost and allow the appeal, Your Lordship, without recording any reasons, even not considering the facts and the decision of the.
What is the period of delay?
Lord, in appeal or appeal?
Order 9 Rule 13.
261 days delay, Your Lordship.
What is the explanation?
My Lord.
Sir, why are you fighting under Order 9 Rule 13? Contest the suit.
My Lord, may I? If Your Lordship, if we can, my Lord, but the point is, Your Lordship, they have made a frivolous statement. Even knowing them, they are false. And making a false statement, Your Lordship.
No, now the happened to the merits of the miscellaneous appeal. Miscellaneous appeal, section 5, what was the delay?
My Lord, may I?
Miscellaneous appeal, what was the delay?
Miscellaneous appeal.
Yes.
Appeal. My Lord, just a minute. My Lord, there was a delay of but there was no delay. That was within time. That was within time.
That was within time. Please kindly come to what are the 21st of March 2025?
Yes, Your Lordship.
It says condones the delay in filing the instant miscellaneous appeal.
Yes, but there is no section 5 application with this appeal, Your Lordship. So in my
this upon payment of this 20,000, the ex parte degree Order 9 Rule 13 was allowed.
Probably that was allowed. But Your Lordship, while deciding that, trial appeal court did not consider the findings, and since they failed to prove their case before the trial court under section 9 Order 9 Rule 13 application, Your Lordship. That was categorical findings of the trial court, Your Lordship. If Your Lordship kindly see come to page 72, Your Lordship, the trial court's order, Your Lordship. To kindly come to page 72 for the trial court's order.
Page
72. The trial court order starts from here, Your Lordship. 72, Your Lordship. I'll stately indicate from the findings of the trial court, page 74. Well, may I read it, Your Lordship?
Yes, sir. How this can be set aside only by directing payment of cost? One line.
No, my lord. First of all, I'll go into the merit of the matter, then I'll come up with the apex court judgments, which my junior friend is holding there.
Yes.
My lord, first of all, my lord, the question of Order 9 Rule 13, whether any explanation has been proper. Because the...
Sir, I am not on Order 9 Rule 13 explanation. Whether
Section 5.
Sir, Order 9 Rule 13 was filed along with Section 5.
My lord.
If application was dismissed, consequently, the Order 9 Rule 13 was dismissed.
Dismissed, my lord.
Against that, you have prepared a miscellaneous appeal. So, in the appeal,
my lord,
payment of cost, line order, cost has been put in, the entire 3-page or 4-page judgment has been set aside. Is this the way?
my lord, as to the my lord, the length of the judgment, my lord, the petitioner, my lord, the appellant petition. I could not hear, my lord.
Judgment which says in such a manner it can be set aside. Show me.
My lord, question is, my lord, I can refer to 2 judgments which my learned friend is having with me, with him. My lord, 2 judgments I'll refer, my lord. The first judgment is M.K. Gupta's judgment, my lord. If your lordship kindly have a perusal of the same, just I'm referring, my lord. M.K. Gupta's judgment, my lord. I'm referring, my lord. Just 1 minute, my lord.
Yes.
My lord, 1 minute, my lord.
2 copies. Sir, you have given me 2 copies at the end. Yes, which paragraph?
Milord, paragraph, Milord, section 5 in, Milord, first, Milord, I'll refer to paragraph 2. Milord, this is exactly the same, Milord, which our case pens up. The plain, I'll start with the first, Milord. It's a reference is, Milord, 2001, volume 6, SCC, page 176, Milord. Kanun has been given.
Yes.
The respondent plaintiff filed a suit under Order 33, Rule 1 of the Code of Civil Procedures against the appellant and other praying for issuance of direction to the defendant to deliver peaceful and vacant possession of the suit by removing the construction, Milord. This is what is also our case. They wanted us to be removed, Milord. Now as the counsel for the appellant did not appear after 79, it is also our case, Milord. We appeared up to the evidence was filed, and thereafter we stopped because of the civil revision was pending, and there is an order of stay. We subsequently, Milord, missed the revision got dismissed without our knowledge. We have filed restoration application. As the counsel for the appellant did not appear after 17/9/93, and the other defendant did not contest the claim of the respondent, the trial court decreed the suit ex parte via its unreasoned judgment dated atho. It was contended by the appellant that the person who was appearing on behalf of the company left the service since 1994 because of the death of his son, and none has informed him about the further proceedings in the court. Unaware about the passing of the decree against him, the appellant could not take any proceedings in form of an appeal for setting aside. He came to know after passing of the decree in 1987 only when he received the notice for execution proceedings initiated by the respondent in the execution case. Milord.
A minute. I am not on Order 9 Rule 13. I am asking about the in the miscellaneous.
Sometimes it is another.
Hello. Can it be done in this way?
Milord, appeal court, we, Milord, as a litigant, Milord, can we dictate the how the order is can be dictated? But we can place our case, Milord.
Right, so
we can place.
Test the decision of the order passed by the appellate court, whether it was on the basis of this law laid by the Supreme Court.
Milord, then again, Milord, then it has to be remanded back because the recent order has not been given. I'll place a case, Milord.
So that when there is ground for setting aside this order.
Milord,
you are yourself saying no reasoned order is being passed. That itself is a ground for setting aside that order. A detailed order rejecting an application under Section 5, maybe how much liberal you are. One line cost, yes, allowed. That should not be the manner in which it is to be done.
But Milord, trial court has also not done it in a proper way. I can refer to the judgment of the trial court.
Sir, appeal court would have said that. Would have said, yes, this is the wrong for which that reasons are to be assigned.
Milord, that way, Milord, then it has to be remanded back, Milord. It has to be for the reasons to be assigned, it has to be remanded back. Because we are not in a position to dictate the court how the order is to be passed.
Yes.
It is the court's discretion. We have placed.
Right. Any other decision you want to cite?
Yes, Milord. Another is Rafiq, Milord.
Yes.
Milord, will I complete the judgment? This judgment, Milord.
Yes. Rafiq.
Rafiq, judgment, Milord, I am referring, Milord. Here also, Milord, the explanation was not proper, Milord. Let me read the judgment. Milord, on knowing that the High Court, will I read, Milord?
So this is on the fault of the learned advocate.
Of the advocate. Here also, Milord, non-appearance is on the fault of the advocate, Milord.
Have you, yes, sir, have you got the receipt? Court.
Another case. No, I'm not carrying your lordship, but
you are not carrying that.
I was, they are saying that referring this case, I was not aware that they are going to place this case, your lordship, because the fault of the advocate, your lordship, because there is no reason of the appeal court order, your lordship. But the thing is, your lordship, the explanation given in the trial court, your lordship, that has not been considered. So, my lord, I was not aware of that. Otherwise, we'll pray for this judgment, your lordship. But if your lordship sends
If your lordship,
tomorrow,
if
your
your lordship kindly has the reasoning being given by the trial court itself. Order 9, Rule 13 has got two portions. One, even I have not received the summons, other I have received, I have appeared but failed thereafter. That reasoning has not been given by the trial court itself also. And my lord, here an exemplary cost of 20,000 has been given.
My lord, page
We
7.
have paid that.
Yes, yes, but that I'm asking him. You have not got the Supreme Court judgment. It says imposition, it should not be done. That's the recent Supreme Court decision.
It's my failure. I am not anticipated he will placing this judgment, your lordship. Otherwise,
So here, imposition of cost it was allowed. You should have brought that judgment.
That's my mistake, your lordship. Well, I'll keep it tomorrow, your lordship. I'll place the judge decision, your lordship.
My lord, the question is, a suit, my lord, will be, we have given the cause, the penultimate provision was provided, we have given our penalty, my lord, we want to contest the suit. It was not that this.
Why fighting out? What is the suit for?
Eviction suit, your lord.
Eviction suit. Even if I relegate this, then miscellaneous appeal. Either way, another round of litigation. Then, provided it is succeeded, then Order 9, Rule 13. So your suit will be delayed. While entering into that, I can expedite the suit.
My lord, the appeal court has already expedited it. It has to be disposed of within a time frame, my lord. That has been provided by the appeal court.
Take instructions from that. Please take instructions from that. Otherwise, you will be fighting on Order 9, Rule 13 and miscellaneous appeal and civil revision. In this, in fact, nobody knows at which point of time it will be set aside and we'll go back to the suit. Please take instructions. After taking instructions, please come.
My lord.
Maybe, yes, you are right that the order cannot be supported, but at times we have to think in other way.
My lord, so my lord keeping it tomorrow.
Yes, when can it
tomorrow, your lordship?
The learned advocates for the respective parties. Please bring the Supreme Court judgment if you are interested in contesting on merit.
My lord, my lord.
Yes, next. Yes, Mr. Mahato, why are you laughing? Nothing. Nothing there in this matter.
Well, suit for declaration of right title interest and injunction. Ad interim injunction granted. Then application for police help was filed. Police help allowed. Police was not taking step, but some steps were taken, but on a particular day, but subsequently when I made
So police help allowed in your favor?
Allowed in my favor.
Why are you aggrieved?
By subsequent event is there, my lord, I made boundary wall, made the construction of boundary wall. The defendants demolished that down, some portion of the.
So you want police help to reconstruct that boundary wall?
That was challenging inaction of the police, my lord. I prefer a writ petition. My lord, writ court directed me to approach the civil court. I filed an application before the civil court, but it's not properly drafted, my lord. However, that application was moved expertly, and that has been rejected with cost of 5,000. My lord, in the meantime, they have appeared, and my lord, they have filed their written objection.
All these things were going expertly till now.
Although they have appeared, my lord.
Mr. Mahato, how could police help be granted expertly?
What I am, my lord, now what I am praying
for your. Those orders can also be
what I am praying
to. I can issue a rule upon you to satisfy how this order can be passed.
What I am praying for, lordship. The defendants have already entered appearance. They filed their written objection to the injunction application. Injunction application has been directly listed on 1st July, but the court was vacant, therefore no step.
So I can direct the injunction application
to be disposed of along with my present application.
What?
Kindly say, because
what application?
The present application for
Mr. Mahato, this cannot be done along with that. Cannot be done along with that. Don't pray for that. If the injunction goes, everything may go in one way.
But so far the cost is concerned, kindly set aside that.
No. 5,000, Mr. Mahato.
It will be punishment.
What was the expenses he incurred in approaching this court? More than 5,000.
Today, this application, not a single paisa has been given to me.
That everybody says.
No,
When they
it is
come-
true, man. No, not a single paisa, 2 rupees has been given to me. 2 rupees has been given to me because I moved the.
And most so, Mr. Mahato, will you be saying that deleting? Have you seen where it has been directed to be deposited? So,
Well,
where are you?
well, kindly,
Advocates Benevolent Fund. And you are challenging that.
well, kindly.
Not any party.
That's true. After all, Maharaj, it
You
will,
pay.
it will be.
Mr. Mahato, you pay. If your client cannot pay, you pay. Not be Advocates Benevolent Fund has been directed. And you are coming up and saying,
In this matter, Maharaj, client will be in difficult.
no, this cost was imposed. Why? Rejecting that application.
I am wasting the court's time.
Rightly. Because the court had to pass such a longish order on such an application.
But today I am only praying
Yes.
My lord, this is my application, my lord. The respondent defendant forcefully occupied my toilet and PV, which my client has been constructed. Thereafter, my lord, thereafter, my lord, without having any other way out, the applicant petitioner filed an petition, a title suit number 194 of 2020, my lord. In the meantime, my lord, the respondent filed a petition under 151 for repairing of the TV, which has been which plaintiff has constructed upon his land. One for repairing the PV and toilet and police health. That the matter came up for hearing on that date. The petitioner became suddenly sick and could not attend the court. Neither the learned advocate was present. When
this application was allowed ex parte.
Yes, well, but the peculiarity is this. So-called notice was issued a fixed date after 30 days to file the so-called notice. In the meantime, the order was passed. Ex parte.
Now, what happened? It has been repairing has been made.
No,
repairing work has been carried out.
Yes, my lord. Yes,
been carried out.
Carried out.
Then what?
No, it has not been completed.
You have said it has been carried out.
No. But for carrying out the repairing work,
yes, the 14th of March 2025 was fixed for filing the police report. What was the police report? Where is the police report?
No police report. No police report has been filed.
The grievance of the petition. Yes. Who is appearing?
But I am paying for expedite disposal of the appeal, which is pending before the appeal court.
Which appeal?
Appeal before the learned additional
municipal appeal.
Pardon, my lord.
Miscellaneous appeal.
Yes, against the order of injunction. I am suffering injunction, permanent restraint by the trial court. I am the owner of the property and the house in question, residential house. Page 54. Page 54. Last one. Only direct the appellate authority, appellate court to decide expeditious as possible, because we have suffering injunction, permanent injunction. I am the owner of the property. Related condition the property in question and house in question also. Tenant file the suit below. I am the owner.
This application under Article 227.
I am appearing on behalf of the. In this matter, my lord, the petitioner is a, my lord, a cooperative society, my lord, cooperative society bank, my lord, registered under Cooperative Societies Act.
Yes.
And my lord, the defendant number 2, my lord,
Order 7 Rule 11.
order 7 was rejected on the ground, my lord, stated there, my lord. My lord, the suit has been filed against the bank, that is non-maintainable, my lord. Because, my lord, it is a independent act, my lord, that has been non-maintainable petition was made and that has been rejected. My lord, though the plaintiff was the guarantor of the loan, my lord. My lord, kindly see the notice. Page 41, my lord. The Mukesh Ali Khan, 3 guarantor. And the order itself is self-explanatory. This is petitioner, plaintiff is the guarantor. My lord. Second paragraph.
Yes, where is the plaint?
My lord, my lord, kindly see page 43, my lord.
Page 43.
My lord. My lord, page 3, internal page 3 of the plaint, my lord, paragraph 3. To auction the house situated over there, possible. Paragraph 3, my lord. The action of the society, cooperative society has been challenged.
Yes, sir. How this suit is barred under the Cooperative Societies Act?
My lord, kindly see the page. Kindly see.
Yes, sir. Can the cooperative societies, under the Cooperative Societies Act, this declaration of title can be granted?
No,
What
my
are you
lord.
saying, sir?
My lord, kindly see.
Sir, this is a suit for declaration of title in respect of an immovable property.
Yes, my lord.
Show me that such a declaration can be granted under the Cooperative Societies Act. Show me under which
My lord, kindly
provision.
see the paragraph 3, my lord.
Yes.
Plain.
Yes.
Paragraph 3. That while
I'm asking you, please satisfy me paragraph 1, relief A, relief B, relief C.
Yes.
Whether is barred under the Cooperative Societies Act. Please satisfy me.
My lord, further declaration that the deed of mortgage executed by the defendant number 1 is a sister of the plaintiff.
A, B, C, I have said, deed of gift.
Yes, my lord.
Deed of gift declaration.
That is mortgage to us. After that, the property is.
Sir,
My lord, kindly see the deed.
after that, it has been mortgaged. The deed of gift has been mortgaged with you.
Yes, my lord.
So, even if you have right over that, deed of gift they have paid for cancellation, declaration that it is void ab initio.
Yes, my lord.
Whether that declaration,
by this mortgage, but by this.
sir, even if part of some of the reliefs are not maintainable, plaint cannot be rejected. That's the well said.
Kindly see the next prayer of the plaint.
I am on the prayer of the plaint, sir.
My lord.
Please satisfy me. A, B, prayer A, B, C. How it is barred under the Cooperative Societies Act? Tell me. This is a deed of gift between two private parties. Show me how it is barred under the.
When the suit was filed, after the recovery notice was given to the guarantor.
Sir, you proceed in accordance with law. Nobody is stopping you. Show me under what provision of the Cooperative Societies Act A, B, C is barred. Sir, title to an immovable property, civil court will not have jurisdiction. What are you saying? Yes.
Any civil court or any consumer dispute redressal forum shall not have any jurisdiction to try any dispute as mentioned in subsection 1. But
yes,
dispute
tell me what is subsection 1. Yes.
My lord, kindly see the notice understand. Notice the after giving the notice, my lord, they come before the
yes.
I file the suit. Kindly see the notice.
Yes.
Page 41, my lord, kindly see.
Yes.
The Muslima Khatun is the loanee. He is the sister of the plaintiff. He is the sister of the plaintiff. My lord, kindly see that at the bottom. Mukesh Ali Khan is the plaintiff. He is the guarantor of the loan.
Yes.
My lord, the property was transferred by her brother.
So show me this is under challenge in the suit. This is under challenge in the suit. Show me.
My lord, kindly see the page 3. Suit, my lord,
Show me the reliefs.
Yes, my lord.
Show me the reliefs
Right.
that this has been challenged in the suit.
Right.
There is any prayer for setting aside that. Show me.
My lord, I'm showing it. My lord, the decree declaration improved deed such and such without illegal jurisdiction to execute arrest avenue such and such address. That who is the property, his declaration, that was mortgaged to us.
Sir, I
That
cannot
property
make.
was mortgaged to us.
Sir, I
Then,
appreciate.
my lord, declaration. My lord,
A, B, C.
My lord, kindly see D, my lord. The further declaration that any deed of mortgage executed by defendant number 1, the sister of the plaintiff, in favor of the defendant number 2, that means petitioner here, my lord, is illegal, void ab initio and nullity, and not binding upon the plaintiff.
Even if it is your submission is accepted, this decree cannot be passed. A, B, C can be passed. Show me that for if some of the reliefs cannot be allowed, plain can be rejected.
My lord, kindly
as
see
a whole.
the suit is not maintainable, my lord. Kindly see the 102 section 4. Upon notice, after issuing notice, my lord, recovery notice,
Under section
4, subsection 4, 102, subsection 4. After taking notice, my lord, receiving notice, they come before the court and file the suit. That there is a
anything more?
There is a pure collusion, my lord.
All right. Anything more?
No, my lord.
This application under Article 227 of the Constitution Dismiss বললাম তো। Yes, call the next matter.
স্যার আপনার বইটা আছে
22.
Lordship, the advocate in record, my lordship, has not come to court, my lordship. So I'm praying for not today, my lordship. One of his family members fell sick.
Not today. Next.
My application, your lordship, for expeditious disposal, your lordship.
Of what?
Your lordship, suit for the eviction, your lordship, suit has been decreed, your lordship. Now,
Suit has been decreed. So
That's-
now what do you want to
the
expedite?
petitioner
Execution.
execution has been filed, your lordship. During the pendence of the execution,
What is the Misc for?
this case under section 47 and one order 9 rule 13, your lordship. And
Order 9, Rule 13 is also there.
also filed. Two
47 is also there.
What?
Which one to be expedited?
Both, your lordship.
Both. Order 9, Rule 13 is fixed for evidence.
Fixed for evidence, your lordship.
This application under Article 220. Yes.
Sorry, my lord, I tried, my lord, but my client is not in a position, my lord, to deposit, my lord. He instructed to deposit, my lord.
Yes.
Not in
So
a,
now what do you want?
my lord, he instructed me to not to press the application, my lord.
Thank you. Yes, it's better if you go before the appellate forum. Otherwise, you have to.
Sir, I want to not to press the application.
Yes, yes. That is why I've said it's better to approach the appellate forum. The
No, no, that is enough.
It is enough. You do not want anything more. All right.
Grateful, man.
Yes.
Yes. I am bring for the petition, my lord. This is the affidavit of service.
Affidavit of service. What? Item number 4 is for extension.
Yes, my lord.
Sir, today it's difficult because you have taken a resolution. Affidavit of service, if it is there, it might be difficult. I'm making it not today.
Grateful, man. Grateful.
Yes.
না।
আর কোনো পাসওয়ার আছে? আর নেই তো? Yes.
Lord, please pardon me. Please pardon me.
Why?
A particular matter, my lord, item number 53. The date is fixed in the tribunal tomorrow, my lord. My lord, it was sought to be mentioned yesterday, today in the morning, my lord, your lordship.
High Court, Mr. Bhattacharya cannot function according to the business of the tribunal.
Which, my lord, I will not speak, Mr. PP. I will, aside comment for.
Bhattacharya, are you suggesting the High Court should function according to the business of the tribunal?
No. I mean, let me try my luck, my lord, today at 4 or tomorrow, my lord, any time convenient to the court. My lord.
What is the grave urgency?
The grave urgency is, my lord, in a proceeding, my lord, moved before the honorable division, when this matter was moved before my lord, regarding that regularization part, your lordship, my lord, was informed not by any caveat or by the KMC that a connected writ petition is pending. As a consequence whereof your lordship was, pleased to pass an order, my lord, directing service and, my lord, directing a returnable date before your lordship. I mean, the matter is coming up tomorrow. I am supposed to, my lord, give 10,000 rupees as costs for, my lord, disturbing the tribunal because, my lord, a particular document.
You have to pay that. If you have disturbed the tribunal, Mr.
According to me, my lord, I am before your lordship. My lord, if it comments to your lordship anytime today, tomorrow.
Who's the other side?
I'll bring the other side, my lord. The KMC is represented by Mr. Devjit Mukherjee and the private respondent is by Shaudhjo Mukherjee. My lord, if it is today at 4 o'clock, my lord, kindly.
4টার সময় কোনো কিছু ফিক্সড আছে? করে দিন। Please bring your other side.
For 53. I mean, the
Item number 53.
Yes.
Matter, 2 PM matter.
I like that. For the reasons as aforesaid, the civil division application stands allowed in part. The impugned order allowing item number 1.
Page 76, my lord, is the order, my lord. In the earlier writ petition, your lordship, my lord, appeared. Page 76.
Since I'm not in Not today. Not today. 26, 3 p.m.
So, Your Lordship, I am appearing by the petitioner. This matter was made returnable, Your Lordship. The opposite party is not appearing. This pertains to filing of counterclaim after framing of issues.
Oh, this is that matter.
That matter, Your Lordship.
Counterclaim?
Filed after framing of issues, Your Lordship. The issues were framed 1 year earlier, Your Lordship. They have, in 2023, they have filed their counterclaim.
Today, in the absence of the other side, it is. Not today, next. Not today.
Milord 28 Milord I appear for the opposite party, Milord.
Yes, petitioner is 28. You are appearing. Yes. Yes.
My lord, this is a civil revision of Public Premises Act appeal seeking expeditious disposal of a matter. My lord, I am being led by Mr. Shubhankar Nag. He's on legs. He's just coming. I'll start till then, my lord.
Yes.
Milord, no difficulty. 2023 appeal. I leave it to your lordship. That's all. Expeditious disposal. What, Milord? What should I say on this? It's between the court and the petitioner. 2023 appeal. That's all, Milord.
Milord, all the problems starting with, Milord, the unconditional stay order passed.
Unconditional stay order. You have.
They have accepted that. It's 2023 stay order.
You are not doing anything.
I will tell you, Lordship, Milord, Milord, see what is happening. Milord, the eviction order are passed, Milord, not in this matter. I am saying.
Have you filed any application for imposition of condition?
No.
I can give you liberty to file an application. I will directly dispose of this, Milord. Pass an order of expeditious. So that will do, because that will further take time.
Milord can record there has been no adjournments on our part on any day. Milord, I am allowed to hear the order, Milord.
It's very difficult, Mr. Nag. How many appeals pending before that court?
That I have to find out, but here.
It's very difficult. If all cannot be done, in that fashion.
No, not all before 12th court.
Many of the matters are before the 12th court.
No, it's before the 12th court because that's the only designated court, like the probate court, the first ADJ, the first sub-judge.
Court, all matters within that jurisdiction will be before.
Yes, it's the 12th court, no other court, one court only.
That fixing that time limit in all matters may be difficult. One court.
It's only one court, one designated court, like the testamentary court in Alipur, first sub-judge.
Chief judge. And some, whenever he gives it to 12th. That is the problem.
That's the only court.
Do one thing, keeping in mind that observations made, I will direct. Killer? PP appeal on 19th of March.
Yes,
PP appeal was heard in part.
13 part, my lord, adjourned on 8 occasion on their prayer. They are saying that they have not done so. I have given the.
No, there are local bar resolutions, Milad, the PO is not there. Milad knows, Milad, what happens.
Mr. Nag, learned advocate, appealing for the petitioner submits that the PP appeal number 7 of 2023 was heard in part on 19th of March 2025, and the next date has been fixed on
July something, koto? 18 July.
18 July.
18 July.
That is the correct date. In the earlier matter, you have given 3 dates.
No, 18 July and 22nd July.
18th July, 2 dates. On these 2 dates have been fixed.
2 dates.
He further submits that 18th of July and 20th.
22nd July.
And 22nd of July 2025 has been fixed for further hearing of the PP appeal. First, in the light of the submissions made by Mr. Nag, learned advocate for the petitioner, the learned additional district judge 12th Court at Alipur is requested to make an endeavor to dispose of the PP appeal number 7 of 2023 as expeditiously as possible without granting any unnecessary adjournments to either of the parties, keeping in mind the order passed by this court on 14th of May 2025 in CO 1167 of 2024.
Well, the affidavit service
Disposed of. ঠিক আছে?
Obliged.
Service filed in court today is taken on record. Yes,
Milad, my appearance may be recorded, Milad, nobody is there to give the appearance. Milad,
Yes.
my part.
appearance recorded. Yes, call the next matter. Opposite party appearance record করে দেবেন.
Obliged.
The plaintiff, my lord, is the petitioner of your lordship. My lord, I am appearing for the opposite party. Before my learned friend goes into the merits, my lord, there is no prayer for condonation of delay. It's a 3rd April 2024 order. Not a single formal
is a requirement, my lord, for
formal. His right as a matter of right to get it condoned.
I shall not.
Even though section 5 doesn't understand
His best point.
and he has not even explained sufficiently.
Paragraph 17, my lord, I have given some explanation. Paragraph 17, my lord, I understand in 227, my lord,
Explanation need not be given.
I have explained, but separate section 5 is not.
We are not in separate section 5.
My lord, kindly see paragraph 17. It's an absolute vague. Let him come back with a formal application.
Application is not necessary. Yes, what is the main matter? Yes.
Not even a prayer. There is not even a simple prayer.
Prayer is not necessary.
As your lordship says.
Show me that the prayer is necessary.
My lord,
Because there is no prescribed period of limitation.
My lord,
But it has been held
I
that
bow down to my lordship.
since it's basically a civil revision application, jurisdiction is being invoked. So limitation under section 150.
My lord, I agree, your lordship. My lord, I bow down to your lordship.
Delay may be explained. Yes.
Yes, the delay, the explanation of delay, because I need to controvert that. Whatever they are saying and trying to
You are so vociferous on this delay, it seems that you have no case on merits.
my lord, I will not submit off the cuff.
So
let us face it.
Let us come
My
to the
lord,
merits.
as your lordship pleases, my lord, I am
Yes.
before your lordship.
The issue, the simple issue before your lordship is not whether an application under 340 of the criminal procedure code, a separate, my lord, application is to be registered as a Misc case, or my lord, no separate registration is required. That is, my lord, the issue before your lordship. Nothing more than that.
What does the civil rules and orders say?
My lord, the civil rules and orders.
I think, Mr. Kormokar, there is a decision.
Lord, I have.
Or have you considered that?
Lord, decision relating to, my lord,
This point.
the act says that.
What?
The rules and orders says that. I shall.
What does the rules and orders say?
Kindly, civil rules and orders.
Civil rules and orders. Technical, Mr. Kormokar, whether it's registered as
The difficulty is because of this.
What happened? Your application has been rejected.
No, that is not.
So the issue is, Lord, 340 they have filed.
Onion in civil rules and orders.
340 they have filed. And Lord, the suit.
They have filed 340.
They have filed 340.
What have you done?
They say.
What have you done?
No, they say, my lord, I have made certain statements on oath which are incorrect. Now, my lord, whether that's a 340 or not, that's on merit, my lord. I shall not take your lordship to
Yes,
what is on
civil
merit.
rules and orders.
Kindly
Which
comes
rule?
to rule 776.
776, yes.
My lord. Kindly comes to 37.
37.
My lord.
37, yes.
Miscellaneous criminal cases under section 195, 476, 478, 480 and references under 146 of the Criminal Procedure Code 1898. Now, my lord, an argument was made in the before the trial judge.
So this is a case under Civil Procedure Code.
Criminal
and,
procedure
and
code.
it is to be registered as miscellaneous judicial case.
Mine. That is what is their contention. That's what is my contention is. Now, my lord, what has been argued and
Because this is basically an application under 195 of the Criminal Procedure Code.
no, my lord, that is not so. Now, my lord, the argument, my lord, I understand this is my application.
That's
Lord,
his
give it get his
concern.
turn. He is
Please take your
extremely
seat.
vociferous. Lord, let us. Now, my lord, the argument that was made before the trial judge, which the trial judge also accepted.
Kormaka, do you have a chair behind you? He has taken your chair. Please, otherwise, you will sit down and.
My lord.
Yes.
Now, my lord, the argument that has been made and which has been also accepted is.
All right, so, let me see the order first.
My lord. Third April, my lord, 2024 is the impugned order.
Push. Mr. Kormakar, how are you affected by this order?
Lord, the affectation, the problem is, Lord, that the suit is proceeding at the same time because this has not been registered separately. Lord, it is proceeding along with the suit and ultimately the suit is getting hampered. Although, Lord, in a separate Lord, revisional application, I have obtained an order of stay because Lord, an amendment or Lord, the other application that is also pending with your Lordship. Lord, that is there. But in the regular course, Lord, this is getting affected. One. The other aspect of the matter is, your Lordship knows, my Lord,
No,
this
one thing.
776.
So it was fixed for hearing on 15th of April 2024. So what happened after that?
After that, because of another interim order, I challenged that and came up before this honorable court. This honorable court,
Which order you have?
Lord, whether Lord Order 7, Rule 11, or Lord another application for receiver, Lord.
That is in the suit.
That is in the suit.
Yes. If
This
I
is also in the
clarify, Mr. Kormukar, that is in the suit. That is according to you, there is an interim order in the suit. I am clarifying that
There is
interim
no
order shall.
There is no interim order in the suit.
Yes.
The interim order has been passed by this honorable court in a separate civil revisional application.
Yes.
There, my lord has already clarified that 340 will proceed separately. And
Yes.
this proceeds
So there is no
separately.
difficulty now.
Difficulty is, Lord, today if the suit is not there, Lord, this cannot be the law.
No, if the suit is now there.
But if 776 wants 340 to be registered separately, it has to be separately registered.
Mr. Kormukar, instead of going to those technicalities, what is the affectation? I am directing this 340 to be disposed of in whatever way, whether it's registered in that or not. How are you affected?
There has been a direction from the Honorable Supreme Court, Lord, to dispose of the suit as a whole within a period of time, not done. Several
That is a different
directions,
thing
not
altogether.
done.
That is now you are 340.
Yes.
So if the 340, as you have said,
once 340 is registered separately as a separate Misc case, no, that will not.
Mr. Kormukar, as you have said, there is an order directing this 340 application to be proceeded independently. How are you affected then? When it's registered as a miscellaneous judicial case, I will keep that issue open to be considered in another matter.
Same orders are being passed in the same suit. No, the problem is in a not in why 776? Not 776 are those proceedings where despite the existence or non-existence of a suit, the proceedings will continue. Kindly seize what 776
That stage has
says.
not yet come, Mr. Kormukar.
But that is
So
exactly what
I am
is happening.
directing this application under section 340 to be disposed of within a certain time.
Keeps this matter pending, directs the court to dispose of 340.
Yes.
Keeps this matter pending.
Yes.
Keeps this matter pending. Keeps this matter pending.
One, is he asking your lordship to sit? One thing he has considered. Your lordship will kindly come to page 46 of the application.
Yes.
My point is, what sort of excuses can an unscrupulous litigant take like this? There is a 340 pending against him for whatever reason, what if he is not coming before your lordship. There is another 340 already pending in another proceeding before this honorable court against the same litigant on the same causes of action. Now the question is, whatever she has done here, this application also deserves to have a 340 in it. This CO, I am telling your lordship, this civil revisional application, and I will come up with such application. But I will show your lordship, kindly comes to page 46.
Yes.
3038 order kindly comes to the last of it. Whatever are the pleading in their application that they were not aware, it was an inadvertent mistake. They could not look at it. They forgot to file, and so on and so forth. Kindly seize the order passed by your lordship's coordinate bench.
No, he has said that 340 will.
It was absolutely in
That's exactly what I said.
My point is not that, my lord. My point is, how many times an unscrupulous litigant will be.
No, you have filed an application under 340. So I am directing that to be disposed of expeditiously. How are you affected?
I am not affected, my lord.
That is the direction which I am passing.
I am being pulled through multiple proceedings in multiple courts, making basically life harassment for me.
That is a different thing altogether. Here I am directing.
The other issue is whatever he has averred in this application, I should be given an opportunity to come back on merits in another 340. I am telling your lordship keeps this pending. I have no issues. I will come up with the appropriate application in your lordship.
Nothing remains for keeping this. I am directing the 340 to be disposed of.
That is already there. That is already continuing under your lordship's coordinate bench's order. Your lordship does not need to pass any further order for that.
No, where is the direction for it says there is no impact having the application hard out.
Yes, therefore
so I'm expediting that. What's the next date fix? I'm only saying that. I'm only saying that
within a specified time.
Your lordship,
what is the stage of that proceeding?
That is being that stage of that proceeding is being heard. The presiding officer got transferred. New
presiding officer has come, now the date is.
Has joined. What
Has
is the
joined.
date fixed?
Next date is on 10th of September, my lord, if I am not.
So I'm directing to take up on that date and
Kindly
dispose it.
kindly directs preponement of that.
Preponement, Mr. Kormokar, is difficult.
The difficulty with this has become a never-ending process.
Mr. Kormokar,
That is because of him.
then I can do. I'm giving you. Then I cannot do from here.
He doesn't even have a right of audience in a 340.
Reporting I cannot say from here because the diary of the
I will have
presiding and the earlier presiding officer has been transferred or retired, whatever it might be. New presiding officer has joined. So, not.
So that's the reason why I was before your lordship not to segregate these two. Once these two are segregated,
Keeping that point of law open.
My lord,
decided
mainly that
to be decided in another proceeding.
my lord, kindly see one aspect, my lord, before your lordship proceeds. May I? The starting of the rule 776. Just kindly have a look at it.
Yes.
Your lordship knows it's a very well settled proposition, my lord. Special laws always prevail over general laws.
But the entire argument as well as the trial court overlooks section 8.
Section 8, your lordship knows of. And kindly sees what is the specific rule in this 776. Any other section that needs to be included has to be specifically passed and added by a full court, full reference of this full court.
That's why section
I'm
8.
keeping that, giving you opportunity to fight out in another proceeding.
That will only lead to multiplicity of proceedings. Your lordship decides, I have no issues in that.
This application.
What more wants? He has got his stay.
Mr. Kormakar, that may be a difficulty because that.
Unless
But
the
again,
other-
a separate blood application has to be
other-
made. But in this application, if I can
Kormakar,
get that order.
there will be a difficulty. If there is any stay and I say, please fix the date, there will be
My
contradiction.
lord will be pleased to take up that other matter. My lord was pleased to say that it would be appearing in the monthly list of July, but it didn't come.
Under what heading?
Under contested application.
Contested application difficult. Let's call the next matter.
Because if that is pending.
Contested application, look, motions cannot be
we are
finished.
looking at.
So
What?
unnecessarily adding those matters in the list will not help. Yes, next.
Lord, the affidavit service may be kept with the record.
We have
The
appeared of
affidavit
The service taken on record.
Get to know.
Yes.
20th.
Your Lordship, I'm for the petitioner in this case. I'm praying for not today, Your Lordship.
Why?
Senior's ground. My senior is actually engaged in courtroom number 35 and he wouldn't be able to make it, Your Lordship.
Not today, next.
That I am for the petitioner. May it please your lordship. Mr. Kaur was in the other side. Well, this is the impugned order we have challenged because of two reasons. Well, one, well, there was no reason whatsoever, and also here.
That is Mr. Kaur.
Lord, I am appearing virtually, if your lordship kindly permits me.
Yes, yes.
Now, my lord, here also, my lord, the question of, well, no condition was set, my lord. So
Section 5, Mr. Nag, it has been
no,
allowed.
it's not Section 5. It's well, the main thing. The lordship on last occasion.
Section 5 Limitation Act has been allowed.
Oh,
That's the impugned order. Which
No.
order is challenging? 22nd of April,
no,
2024.
March 2025.
10th March 2024.
10th March order.
No. এটা অন্য file দিয়েছেন.
Oh, 31.
That is why I'm saying that Section 5 has been allowed and you are challenging that.
No, that is not the issue. Issue was who was in possession. So on last occasion, lordship's pleasure
was who is in possession.
When lordship sees the impugned order, very short one. The learned advocate for the respondent submits that the application for stay of operation of the impugned order.
You took time. You said that why you took time on the last occasion?
No, last occasion it fell from your lordship. Either I said that I have to take instruction. Two options were given. First option is to file an application so that it can be enhanced, or lordship is going to pass an order so that the matter can be disposed of, because the next date is 4th October 2025. So I was supposed to take my client is of the view that within 2 months or so the matter can be disposed of.
Which court? 12th additional district judge.
Yes.
Yes.
Sir, Nag, all matters.
No, it's from South Pargana.
Yes, that was also Alipur, 12th edition. What are you doing?
No, my lord, here, my lord, I have to praise, my lord, why I tell you.
No,
My
this
lord,
is
here-
no,
here,
sorry.
I
This is
tell-
district judge.
It's the 16th court. It has been transferred.
No, my lord, here, my lord, the problem is, my lord, the monthly 17 lakhs in terms of SOR, and on my lord,
Mr. Nag, if you want, I am giving you liberty. You can file an application that will be
kindly for disposal. My lord, one thing, my lord, on last occasion in a different matter, lordship asked for the Supreme Court judgment, where, my lord, it has been said, my lord, the scale of rent has to be paid in case of disposition. Just
Now you don't want that, so don't place that. Unnecessarily, you can place it at the appropriate time. Yes, Mr. Kaur,
Yes,
direct.
but I have no objection. Kindly not expedite the hearing of the appeal.
Nag, where is that judgment?
Oh, I just gave in 28.
এই 28 এ ফাইলটা দেখুন তো একটা অর্ডার
ওখানে
আছে
judgment. Because
চলে গেছে কিনা কে জানে
28th.
Can you give the cost title? Only the cost title and the order date. This application under Article 227. I think the file has gone.
I will just.
Please give me the cost title and the date. This application under Article 227 of the Constitution of India is at the instance of Shama Prasad Mukherjee Port, Kolkata, and is directed against an order being number 3 dated 10th of March 2025 passed by the learned district judge in charge in PP appeal number 6 of 2025. First up, by the order dated, no, by the order impugned, the
Only the appeal has been admitted and Lord, a stay has been granted upon.
impugned, the appeal was admitted and an order of stay of operation of the judgment dated 12th of February 2025 passed in proceeding number 805 of 2006 was passed subject to condition of payment of monthly occupation charges. First up, after some argument, Mr. Nag, learned advocate, appearing for the Mr. Nag, please hear this. After some argument, Mr. Nag, learned advocate, appearing for the petitioner, submits that he has instructions to pray for a direction for expeditious hearing of the PP appeal. First up, Mr. Kaur, learned advocate, learned senior advocate, appearing for the opposite party, submits that the opposite parties do not have any objection if the PP appeal is heard expeditiously. First up, paragraph.
Judgment.
What is the next date fixed?
4th October.
10th of, oh, okay. That this order records 10th April, but thereafter the date must have been
passed. So, Mr. Nag,
4th November, I'm sorry, 4th November 2025.
Mr. Nag, you are giving
I'm
different dates at different points of time.
No. We found it from the court record.
That the advocate appearing for the petitioner submits that the that 4th of November 2025 has been fixed for hearing of the said appeal. Mr. Kaur, have you entered appearance?
No, but it's my appeal. I have preferred the appeal.
You have entered appearance because 10th of April was for appearance.
Yes, we have.
So this order was passed ex parte.
No, I was there, man.
No, he was there.
No, sorry, appears before the transferee court.
Yes.
Both have appeared before the transferee court.
I think they have. I don't know, but I don't have the exact.
The next date has been given on that. That's
so. I record your assurance that both of you will appear before the transferring court on the next date.
Very
well. It appears from the order sheet that 10th of April 2025 was fixed for appearance of the parties before the learned additional district judge 16th court at Alipur district 24 Pargana South, before whom the appeal stood transferred. First up, the learned advocates for the respective parties assures this court that the parties shall appear before the before the learned additional district judge 16th court at Alipur on the next date fixed. First up, in the light of the aforesaid,
next date maybe prepone, 4th, 11th.
Then you file an appeal.
Lordship sees,
Mr. Nag, preponing from here, it is difficult. I do not know the business.
Liberty to make an application to prepone the date,
Yes, I will give you liberty. Both cannot happen at the same time. All matters, directions, preponing. So that additional district judge will hear only the PP appeals, no other appeals. Akiola? Made by the learned advocates for the respective parties, CO number such and such stands disposed of by requesting the learned additional district judge 16 court at Alipur to make an endeavor to dispose of PP appeal number such and such, keeping in mind the order passed by this court on.
Well, just a moment. I just handed it over to your lordship.
Passed by this court on, Mr. Nag, please put it in a piece of paper.
Yes,
passed by this court on such and such in a batch of civil division applications, the lead case being CO number such and such. In the case of Shama Prasad Mukherjee Port Kolkata versus ki boda Kejriwal, Bhagirath Kejriwal naki. Full stop. ঠিক আছে?
Well, it is CO number 1167.
Keeping in mind the observations made by this court in order.
CO number 1167 of.
Please put it in a piece of paper. The cost title, order date, CO number.
much obliged.
The first cost title, first name only. First CO number and yes. Call the next matter.
Respondent section 5 application allowed.
That has been challenged. I have never seen this type of section.
You have not seen.
This type of section 5 challenge I never seen.
Lord, may I submit,
time
Milord?
I've seen.
I am the petitioner. I'll ask my learned senior friend to not, and he has rightly pointed out he has not seen. Because, Milord, I have also not seen the prayers made by them in the Section 5 application. Such glaring errors, such malafide intention has been on the face of the record. And even after that, Milord, the Section 5 has been allowed. I'll not trouble your lordship. I'll just take your lordship. Now, what is this case about, lordship? This is
Section 5 in connection with what?
in connection with an application, lordship. I was a petitioner regarding wages. This was filed under West Bengal Shops and Establishment Act for recovery of my wages. Now, I succeed in the matter where they also admit my claim. They admit, yes, the amount is due to you and we will settle the matter. Then they don't appear. The learned referee passes an order with compensation to pay me. Now, when that order is passed, they remain silent. They remain silent till the execution. I put this order into execution. Because the process is that, my lord, I'll have to write to the learned referee, that is the labor commissioner. Labor commissioner will give them an opportunity for show cause. If they don't do that, a criminal proceeding will be drawn up. It was only when they received the letter from the labor commissioner, they put in this appeal stating all the
What is the period of delay?
Now, period of delay is 162 days, my lord. But I'll only show lordship only the grounds of they have what the grounds which they have taken, lordship, and that is at page 23, lordship.
Sir, I'm expediting the hearing of the appeal. You can execute your.
My lord, only one. I will, my lord. Only one. What I'll say, my lord. They say that this particular gentleman was the authorized representative. However, he was not the authorized representative. A new person had stepped in. Then they file a medical certificate saying that he was.
I'm expediting the hearing. This application under Article 227.
Lordship, poor workmen, some cost be imposed upon them, poor workmen, some money we put in, some money we put in there. Hey, George,
My lord,
the amount of the only 50% maybe
you could have paid that before the law.
that,
my
my
lord,
lord,
that is the appeal, my lord.
order of
It
the
is-
learned judge.
It is not
learned-
maintainable, my lord.
Appeal is not
Their
ma-
application, my lord. My
It
lord,
is their
they-
admission
They
to
have
pay.
fought among themselves in a good
All right,
prestigious court. Section
I'm expediting this application under Article
But a different petitioner, all the same.
33 same শুধু ওই নাম্বারটা yes
That is an ejectment suit. Ejectment suit, Millard. Of course, reasonable requirement ground is there. Now, Millard, the suit was fixed on 29th of April, 2025 for fee hearing. Now, Millard, the kindly come to annexure.
yes what happened all of that rule 7 allowed
No, Millard, I am not on that. I know, Millard. That's the reason at the previous Millard, I have submitted this suit for reasonable requirement. But the only thing is this, that Millard is they are asking for an hotel business because they got sufficient hotels just nearby. We have made in the written objection that they got these hotels, and we have because we have got not opportunity to place those papers. Now only
Why
in the
written objection considered
no, kindly see.
On the other hand, by filing written objection, it is stated.
The word considered, Millard, kindly see the.
Show me your written objection.
Yes, kindly come. I will be grateful to you, Lordship. Millard, it is page 40.
40.
40, Millard.
Yes. Which paragraph?
Yes, paragraph 4 and 5. Page 41. Paragraph 4 and 5. In 4 middle portion, she got huge accommodation at her other premises at 13.
What is the food property? Food property
14.
14 Mahatma Gandhi Road.
Just opposite Millard. But they are not taking the Millard records of this.
No. Show me the plaint. Where is the plaint?
Yes, Millard. Plaint is at page annexure A, Millard.
14A, not 14.
14. Millard, renumbered as 14A now.
So 14A
yes.
is the suit property.
Is the suit property.
Now,
Millard, it's page 18 and 19. Millard, 18 is the paragraph number.
Yes. So what is your objection? According to you, there are other several all the hotel business in and around the suit property.
We got all the papers, but we have not got the opportunity to produce those papers even.
What do you want? You want those premises to be inspected?
Only.
So you file a for that.
You Lordship kindly give the liberty.
No.
I have stated this. Millard, kindly see that we have.
No liberty is there, sir. You have to apply for that.
What is there, Millard? What is there?
Sir, where is the application for local inspection? That was only considered.
Millard,
so you file an application that will be considered.
Millard, kindly see that what is the application? Order 39, Rule 7, page
Yes.
57.
So these are the points.
These are the points, but these points has not been allowed.
Where are the points? You have not filed any application. Please file an application for that.
I have in the written objection, I have stated.
Yes.
I have stated in the written objection specifically.
Yes.
If this commission is allowed, then obviously these premises also be considered.
Take out an application for that.
Then you'll also give me such.
What is this?
Otherwise, the only problem is that the trial court, if your Lordship will reject this application, the trial court will say that your application has been rejected, it will not be considered because
that is not your application.
It is the application.
This application under Article 2, this application. with the order impugned. Whatever has not been allowed, it has not been allowed. Yes, next.
Lordship, it's my application. I'm the husband.
Any caveat is there?
No caveat, Lordship. This is an order. I've come up before an order of maintenance. Now, Lordship,
what is the amount of maintenance?
6,000 for the wife. 6,000 for the wife. I'll tell you why this is not sustainable. I am earning 61,000, admittedly. That my pay slip is there. This is the affidavit of asset of the wife. This is the affidavit of my asset. Everything is there on record. My wife is admittedly earning. I have stated she's earning more than 70,000. She's saying I'm earning 15,000. Court has come to a finding that she has not come with a clean hand. I am paying everything towards my child. I am paying 10,000 per month towards my child. That is recorded in the order admitted by the wife. I am paying all the tuition fees of my wife. Now I have bought a flat out of which I am paying an EMI of 26,000. That is being possessed by the wife and she has thrown me out. For that I have to take an accommodation on rent. 1,000. I am already spending more than 61,000 from my pocket. How
Show me the court finding with regard to the income of the wife, Lordship.
Kindly come to the impugned order itself.
Yes.
I wouldn't have bothered your Lordship for 6,000, but this is entirely different matter. Lordship would kindly give me 1 minute. Lordship, I beg pardon, just one minute. The decision with reason is there.
Sir, I've got that.
Lordship. Aforesaid salary
Contractual employment.
Contractual.
I've got that.
74,000. I am having 61. Still paying for the child. Still paying for the EMI.
Contractual employment, how much she is earning?
74,000. That is the.
That's your allegation. You could not prove.
Maybe. She's admitting there is an employment. She's earning more than 15,000 as per
From your affidavit of assets, you have not annexed that. Let me see your affidavit of assets, sir.
Actually, Lordship, this big. This is the affidavit.
Show me your affidavit of assets.
Lordship. This is my affidavit of assets. And there is a supplementary that I've annexed.
Yes. Show me your statement with regard to your income and expenditure.
This is Lordship, the affidavit of asset where the wife is categorically admitted of her income.
Right. Show me from your affidavit of assets, what is your income and what are your expenses? Monthly expenses.
Specifically stated there, Lordship.
How much? How much?
Lordship, 61,000 is my income.
Yes.
25,600 something I am paying for EMI. 9,000.
How much? How much?
25,547 I am paying for EMI. For the flat which my wife
that
is
cannot be deductible. That is not deductible. You can also spend 35,000.
Allow me to reside in my flat. She has thrown me out. I have to take another flat on rent and paying 9,000 for that. That wife is admitting. That also admitted by wife, Lordship. I am straining myself out. Then I have to then stop making payment for the child. Again, this will go on. She is earning, yet I have to pay 6,000 to her from the date of order. Now she has filed an execution case for arrear also.
Where is the income tax return?
Is there, Lordship?
Which page?
I'm a salaried person, so my salary slip is also there.
Yes, yes. Show me your income tax return. You must be an income tax payee. That is not here.
Lordship, last TDS certificates are there. Last pages of the affidavit. All the TDS certificates are there. Kindly see.
Kindly come to the second page, Lordship.
Uh,
Page number internal page 5 of the order.
I'll let you serve.
I am only showing one thing, Lordship. Kindly see.
Petitioner, the learned advocate appearing for the petitioner.
Maybe straight. I am paying. I'm still paying.
Nothing will happen. Thereafter, it will be adjusted.
Already DW has been issued against me.
What did? Please pay. Nothing will happen.
I am paying 6,000. I can show all the receipts, but for the year,
if you are paying
year is
6,000,
140,000.
you show that 6,000. That's the order 6,000.
That is okay, but area amount. For 1 lakh, for 38,000 of area amount, she has filed an execution for which already warrant has been issued against me, Lordship.
Let them come. Yes.
Kindly, sir, for limited period, Lordship. For limited period, only for that portion. The area amount, nothing more than that amount.
You deposit that amount.
I beg, Lordship, I don't
deposit that amount. Sir, money.
If I have that money, I would have paid.
Secure. You did not pay to the wife.
I am paying 6,000. I am ready to pay continuously.
Please secure that amount.
Kindly stay on the deposit that. Lordship, kindly stay on the condition to pay every month.
No. Yes. If you are paying 6,000, please pay.
Only I'm paying. On condition of payment, kindly deposit that.
Deposit that.
I deposit 6,000 every month. But I don't.
Where you are depositing? You are paying.
I'm giving directly to my wife.
Yes, the balance amount. Deposit, I will pass an order of
it. My amount, Lordship. I am making it very candid, Lordship.
Yes.
I have been.
Yes, call the next matter. Call the next matter.
Much also.
Yes.
Your Lordship, I am the petitioner in person.
Yes.
This is a ejectment suit along with 340 read with 195, which has been already passed by the coordinate bench in favor of the 340. And this impugned order, you will notice on the order number 63 dated 2nd April 2025, where in the 12th line of the order, it has been mentioned that court number 1 to 14 will be in the circuit bench, where I have asked for only 6 and 22.
I could not follow on the prayer.
Which has been mentioned that 1 to 14 will be in the circuit.
Resolution circulated court number 1 to 14 will not be there at present due to circuit bench.
Yes, Lord. And for that it has been cost 10,000. Petitioner has been cost 10,000. And second thing, this 340 which has been set aside by Honorable Justice Jamala Bakshi. And that in the Misc case, it has been shown as a show cause without uplifting the order.
Yes, which portion of this order you are affected?
That is 10,000 which has been cost, which has been made because I have appeared for code number 6 as well as code number 22. Because the order of 37, which has
must has been directed to be paid.
Yes, Lordship.
By the plaintiff.
By the plaintiff in the last para of the order. Because order number 37, which is under challenge, Your Lordship, before code number 22, now it is under code number 25. Honorable Justice.
So you want deletion of that cost?
Your Lordship.
Ashun, this application under Article Not today, next. You are appearing.
Lordship, I am for the petitioner. Yes, Lordship, I am in the item number 37, Lordship.
Yes, yes.
Item 37, Lordship.
7.
Yes, here is the, I am for the petitioner.
Yes.
Petitioner is the wife of the opposite party. They got married in the year 2000, and here is the opposite party filed for a match suit, and the petitioner has filed a miscellaneous application, Lordship, for the pendentile maintenance under section 24 and added with 26. The impugned order is in page number 104, Lordship.
Yes.
Yes, in the order, the petitioner has paid for 15,000 for herself and 10,000 for the son. Now, Lordship, in the impugned order, only meager amount 3,000 for the petitioner and 5,000 for the son has been allowed. Now, Lordship, yes, Lordship.
Sir, the petitioner is aggrieved by the quantum of maintenance directed to be paid by the husband to the wife and the minor child. The petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter under the heading contested application in the monthly list of November 2025. Yes, next.
Well, this was that matter, my lord, where we had come up, my lord, against the Waqf Tribunal order of 29th April, my lord. My lord, the property which was purchased by us, my lord, had been pleased to, my lord, grant a stay, my lord, till the end of July, my lord. My lord had been pleased to observe, my lord, here, this matter, we had purchased the property on auction, my lord, prior, my lord, to the Waqf amendment law, my lord. Where
the stay is there. Who is for the opposite party?
For the state. Nothing is against the state.
My lord, opposite party. Last time
unless the opposite party is here, you have taken a resolution.
Yes. Tomorrow is also there.
Not today, next.
Board is 35 দেখাচ্ছে
Yes, Mr. Basu, what makes you agitated?
Agitated board is 37, so I was just missing the matter.
So 37 was just now.
See the consequence. If I miss it, what will happen?
You are in 30?
I'm being late.
Just now you're missing.
You want your presence to be recorded, Mr. Basu? Yes. All right. 38 at a record করে নিন তো Mr. Basu, learned senior at
And the resolution today and tomorrow also.
Tomorrow?
One. And on tomorrow I will not come. Whatever form any political party called, I am there. I am fond of bond, not the fond of political parties.
সে অর্ডার রেকর্ড করতে হবে না তো নোট টুডে করে দেবে
হ্যাঁ ভেরি গুড
অর্ডার রেকর্ড করতে হবে কন্ডিশন যদি মামলা করেন I've not done. I'm making it only not today because today there is a resolution.
That will do.
Yes,
then
next.
Tomorrow also same thing will happen. Then make it day after tomorrow.
Let it remain if tomorrow nobody comes.
Already circulated to my lord.
If the other side comes and you also come.
I will not come. On I support.
Mr. Chatterjee will be there. 39, yes. Yes. Who is appearing in 39? Seven two rejected. Mr. Ghosh, caveat is there? No. 7-2 has been rejected.
Read up to paragraph 2. Director has not read other paragraphs of the 70 application.
No, what is this item number? 30? Oh, yes, yes. Order dated 27th of September 2024. Yes, you have been defendant is a defaulter in payment of rent. Yes. Admitted amount of rent not deposited.
That's why we here read up to paragraph this, but you will come to the application.
Yes, page
Page 19.
19.
One.
Yes.
Paragraph 2.
Till October 2016.
Yes, next. Clearly, what was estimated thereafter then date to clear. The reporters made January 19, subsequent dates were routed and it was stated that they have been paid. There is no default. And it has been paid that is to determine whether I have a default or not. And it will be
Oh no, Mr. Ghosh, you are sending through money order. What is the fate of those money orders? You have not stated that.
therefore, at the time of hearing, I shall produce the receipt. He at the threshold, going through paragraph 2, he has rejected my application and 7C has been allowed.
But Mr. Ghosh, when have you filed this application? When the summons was served? Within time? Is it so? Because the suit has been filed in July 2017 and you have filed this application in November 2018. It took more than 1 year to serve summons. What did you say with regard to service of summons? You have not said anything.
I have
There is substance in the submission of Mr. Ghosh.
My lord, in this 40, my lord, I have also annexed the impugned order for my lord's convenience.
Yes, bank is before the court as petitioner. Unheard of.
What happened, my lord, is basically a SRPC action.
Yes, yes.
Bank
opposes the
bank filed an application for maintainability of the payment was instituted by the is the collusive suit instituted by the borrower and the father. 47 Rule 11 filed with the bank, allowed by the learned trial court. Against that, my lord, the defendant, the plaintiff preferred appeal, appeal was allowed in favor of the plaintiff,
thereby restoring the suit.
restoring the suit, my lord.
Show me the prayers in the plaint.
No. My lord, I have also a translated copy of this.
Translated copy. Show me the vernacular.
Vernacular.
Translation, I do not know. What have you translated?
My lord, my lord.
Show me the vernacular.
My lord, page 21, my lord.
Yes. How this suit is barred under section 34? 34.
34, my lord.
How this suit is barred under section 34?
Because what happened, my lord, in this matter? They are now challenging
the judgment of Justice Pardiwala in 2020.
Yes, yes, 2025.
Considered.
My lord.
I think I have considered in your another matter.
In other matter, my lord is considered.
So that goes against you in
No,
this
my
matter.
lord, I'm coming to that point, my lord. What happened in this matter?
This
position,
these prayers can be granted by the DRT.
position was taken, no.
Sir,
Cancellation of the deed may not. May not.
Granted.
Cancellation of the deed. He is praying for cancellation of the deed. But why I say, because this is a frivolous prayer, my lord. What happened as DRT proceeding was going on? The defendant number 3 there herein was a party to that.
Sir, is it one of the measures under section 13.4?
Not 13.4.
This is one of the measures.
No, one of the measures.
There is no challenge to the measures under section 13.4, how such a suit is barred. Sir, you have considered, I have considered that judgment, recent decision.
Today I am not armed with that. If I make...
No, not in that matter,
no, my lord has...
so,
today I am little bit indisposed, my lord. If I can come back on some other date, subject to my lord's sanction.
3 prayers in that plaint considered, 2 prayers.
Yes, my lord.
The DRT do not have jurisdiction. Civil court has the jurisdiction. 3rd prayer with regard to possession. 2 views. Yes, civil court has the jurisdiction. Even if it is accepted, DRT has the jurisdiction. Plaint cannot be rejected in part. So, Order 7, Rule 11, rejected. That's the finding. These prayers cannot be granted by the DRT. Appeal court's judgment is right without seeing that. What did the appeal court hold?
My lord. I have also annexed it, my lord, from page number 152, my lord.
152.
15. I also annexed it separately.
Yes, sir. Certified copy.
From the certified copy, my lord.
Yes. Yes, ultimate conclusion, page 16, correct, of the appeal court judgment. Section 34 is not the magic word of surface. Yes.
My lord. What happened in this matter, my lord? DRT proceeding was going on. The property was put under auction.
You do whatever you are entitled to, you proceed with your auction. Nobody is here in this suit. None of the action under section 13.4 measures are under challenge. It's pure and simplicity dispute between two private parties with regarding an immovable property that is the subject matter of challenge in this suit. How such a suit is barred? If you want to consider that judgment, that is exactly.
But the overall, my lord, the whole thing is, my lord, premised on the SRPC actions, my lord.
Sir, I am bound by the Supreme Court decision. Very beautifully, it has been, each and every relief has been considered. Why it is not barred? You are aware, I have relied on that judgment. 2025, I do not know this. SCC online.
I'm having
SCC online. So, Justice Padiwala's judgment. Yes, Prabhajan, yes. So, that's the recent decision, and it has been held that plaint cannot be rejected in part. That's the finding. 3 reliefs were there. 2 were with regard to declaration of deeds.
Central Bank of
Third was with regard to possession. On that, there were 2 views. Civil court, URT, both, even if it is accepted, plaint cannot be rejected. Yes, what do you want?
Central Bank versus Prabhajan.
Mr. Bordhan knows the cost title by heart. I don't remember those.
He's regularly doing matters on this subject.
Yes, what do you want? You want to consider that?
My lord, may I come back? I'll be wasting my lord's time ultimately, if so. But
I have given that reference on the next day. Please come. Don't.
No, I will not.
After going through that, as an officer of the court, you have to.
He says that.
No support to the bank. No support to the bank.
No, I was astonished. The bank is for the petition. I thought it's for the opposite party.
Sign the bank starts coming up.
Yes, call the fixed matters. This was 40. Yes, or 40. Acha, 40 that order record korun. Any recording is necessary. It will help you. Ashun. After all the decisions, previous decisions on which it was held, section 34, all the decisions has been considered. You can see the first portion. Subsequently, there are other issues, fraud and other things, what will be there. I don't think those are also issues here.
There is also a judgment of Honorable Bombay High Court, Division Bench, Gopal Sriram.
Bombay, what he will do? No. Supreme Court is here now.
So that is very elaborate. Very elaborate.
Supreme Court it has clarified. Yes. Yes, for the next one. Call the fixed matters.
My lord, item number 378, which is the fixed matter at 3 o'clock. This is my application. My
Yes.
lord, I'm aggrieved by the order dated 2nd December 2024, rejecting my order 7 rule 11 on the ground that the property, the suit premises in question is a Thika property, and I am a Bharatiya under the predecessor in interest of the present plaintiff. My lord kindly takes the impugned order once. My principal ground in the order 7 rule 11. My lord, the plaint is annexed at page 29. commencing at page 29. My lord kindly sees, although the plaintiff has categorically suppressed the fact that it is in fact a Thika property, what gives away the fact is that the schedule of the plaint and the pleadings in the plaint describe both the suit property and the entire property by its premises number. Lordship sees the premises number is marked with an H. That shows that it is a Thika property. My lord kindly takes the schedule of the plaint at page 35. Kindly sees, my lord, premises number B by 1 by H by 73. My lord, my contention in the Order 7 Rule 11 was that it is barred by sections 8 subsection 3 and 21 of the Act, my lord.
Where is your application under Order 7 Rule 11?
My lord, my application at Order 7 Rule 11 kindly gives me one moment. Yes, my lord, it is at page 54 of my application. The material pleadings, my lord, at page 56, internal page 3 of my application, paragraph 5, 6, 7, and 8 especially, my lord.
Tenancy.
May I place, my lord, section 8(3) of the Tenancy Act?
Give me a minute.
Yes.
Mr. Borton, has the reference been or the point been answered? I think that was pending. If a proceeding for eviction of a bharatia is instituted, so the provisions of West Bengal Premises Tenancy Act 1997 will it will be governed by that. So there was a dispute that because 7(2) it is referred to a larger bench. Mr. Chatterjee, where Mr. Chatterjee? Why are you looking here and there? Has that issue been answered? I think eviction of a bharatia.
No, Justice Tandon's judgment.
Yes. Has that been answered? What is the decision?
No.
Controller.
No. Civil court.
Civil court.
Justice Tandon's judgment.
Yes. Justice Tandon was hearing that.
Yes.
But I do not know the final decision.
No. He held the civil court.
So not before the controller.
Before the controller.
Because the 7 compliance, section 7 compliance has to be before the civil judge, the controller.
Absolutely.
Can you give me the judgment? Madam, please consider that judgment.
My lord, I will consider that judgment and come back.
Civil court section. So
my lord, in the meantime, may I just hand up one judgment I have found? It's a 2016 judgment of the coordinate court in a civil revision. My learned junior is there in court to hand up a copy of the judgment.
What is that?
This is, my lord, identical circumstances. 711 rejected by trial court on the ground that no civil court will have jurisdiction. My lord, the relevant paragraphs, if I may place, my lord, kindly sees paragraph 14, 16 to 18.
This was also an eviction of a Bharatia.
Yes, my lord. Eviction of Bharatia, 711 preferred, rejected,
Then it-
revision.
If there is a
There's a divergence views. That's why I said, has it been referred?
it is to be referred.
I heard there were divergent views. I said.
Mr. Chatterjee, when can you give me?
Siddhartha Chattopadhyay.
Yes, yes. Honorable Justice Siddhartha Chattopadhyay.
I'll find it. I'll find it out for you.
Because then, if both are by the, then it's to be referred. I do not know whether Justice Tandon has considered this, because which one is later? This is of 2016.
Justice Tandon at Pore.
Justice Tandon's judgment has to be after that.
Ah.
Has to be after that, because I was there then. So,
Somewhere there was divergent views. I heard somewhere.
any references?
Division bench দিয়েছিল।
Justice Tandon in the division bench?
Division bench.
Then there is no.
First appeal.
No, Justice Tandon, when Justice Tandon was sitting singly, this point
His
cropped up.
lordship, in this matter,
I think courtroom number 2 or 4. So it cropped up.
I'll give you a lordship the judgment.
Mr. Vidyut Banerjee was there. He was arguing in that.
That was a stage when they were Mr. Raichaudhuri also.
Mr. Raichaudhuri was also there. Mr. Vidyut Banerjee were there. So this was the point cropped up with the section 7. What will happen to section 7?
Because you don't have the paraphernalia under section 7 to take the money, keep it in a civil deposit. They don't have that.
Yes, controller do not have that. And you cannot deny a tenant those protections which have been extended by the act.
Yes. I remember. It gives me a day. I'll find out in the evening and tell you. Tomorrow, Miller, of course, is not. We are not coming to court tomorrow.
Why?
Day after tomorrow, I'll.
Why tomorrow?
Tomorrow, Miller, we are laborers. We are laborers.
You will not appear virtually.
No, virtually we don't know, my lord. Virtually.
All right, I will remember this.
We can.
I will remember this. Ashun.
এখানে তো 19(1) G এর নামে violation of. Virtual direction. But if possible, I'll set it tomorrow itself.
I think admission, it has to be admitted.
Definitely.
Requires admission.
It's an arguable point anyways.
By the order impugned, তার আগে একটা লিখে দিন and file an appeal service on the next date. এই সার্ভিসের অর্ডারের আগে একটা লিখুন, the learned advocate appearing for the petitioner places reliance upon a decision of a coordinate bench in the case of Srimati Suchita Ruiya and others versus Vikas Fabrics Private Limited and others, reported at 2016 3 CHN 376 in support of her contention that the civil court's jurisdiction is barred in a suit for eviction of a Bharatia. First up, paragraph, এটা পরে তো সার্ভিসের ডিরেকশন, তারপরে লিখুন there shall be an order of, since an arguable case has been made out, there shall be an order of stay of all further proceedings in title suit number 97 of 2021 pending before the learned civil judge junior division first court at Shialda till the end of the month of December 2025 or until further orders whichever is earlier. Contested application monthly list of November. Yes, call the next matter. Mr. Chatterjee, please give me Thursday this judgment because this may. Yes. You said you will not be coming. Yes, who is in this matter? Not today. Next. One 88. Ache. Not today. Next.
My application, but they are enjoying an interim order from
Application for vacating.
Yes, DRT order.
But Mr. Chatterjee, vacate.
After my lord's judgment, not order. DRT order.
What judgment I have passed?
I have to go to DRT. I can't lose everywhere.
Why?
I can't lose everywhere. Somewhere I have to win.
Mr. Chatterjee, they are not.
I understand that, Lord, but problem is, Lord, I'm the bank and I can't, Lord,
Mighty bank.
any day, Lord,
You are the mighty bank.
I'm not the mighty bank. It's public money.
I'm making it not today. Mr. Chatterjee.
But may retain its position. Tomorrow there will be a problem. Again, Mr. Thakkar will
Mr.
not.
Chatterjee, the difficulty will be the more the list progresses, the days progress, the accumulation will be more.
That's true.
Because tomorrow some matters are fixed. Today's matters are not being taken up. So accumulation will be there. Mr. Chatterjee, please take it back. Place it up.
May I pray for this, Lord, because anyway, your Lordship, Lord, feels, Lord, it's. I'll inform Mr. Thakkar. He's for the other side.
Mr. Chatterjee, this will remain in the position, but I do not know because.
Lord, that's my problem.
No, what position? It's position fixed matters. It will appear there. It will return, but more matters will come in that group. That's the accumulation. That risk you have to take because you will be on the third day. Second day, some matters are fixed. Those will be there. If those are adjournment, third days. So 3 days accumulation will be there.
No, I understand, Lord. It's a practical difficulty, but.
And because Mr. Chatterjee have fixed dates long before, so those matters are coming because I did not knew about these days.
None of us.
So that is why I fixed these matters. That's the only problem. Otherwise, considering the urgencies are fixed dates, but if it is not taken up, it will be difficult. Yes, call the next matter.
Order the bank.
Nothing will happen. You cannot take both.
Bank.
You cannot have the cake and eat it too.
But
You have
what's the
explained
point?
the difference.
I was explained by Justice Shavadkar. But then bank. Bank human again, not a private client.
The advocate on record is here. He will
He
take.
will also, Bechara, not for me. It's for him. আমার জন্য না।
Nothing will happen. Yes. Yes, who is in this matter? You are for the other side.
Yes, ma'am.
Yes, Mr. Bordon.
Petition, my lord. The defendants in a suit for declaration in an injunction, my lord, rejection of my application under Order 7, Rule 11.
Order 7, Rule 11 has to be rejected.
Not always. My lord,
Yes.
the plaint is at page 24.
Part under which act?
Consumer Protection Act. Orders passed by the Consumer Protection by the District Forum, they attain finality. They cannot be sought to be reopened in a civil court. Section 24-25 of the Consumer Protection Act.
That is under challenge.
Yes, kindly seize.
Where is the plaint?
The plaint starts at page 24. The reliefs, my lord, are at, my lord, page 32. My lord, the plaintiff, my lord, says that she is a co-sharer of the property. and a unregistered development agreement has been entered into. That
So this was the prayer before the district forum,
kindly,
district commission.
kindly, kindly cease. Now, kindly cease the cause of action. The cause of action is at paragraph 6 at page 32.
Yes.
That the cause of action of the suit firstly arose on having summons on 2415 from the District Consumer Forum in CC 138 of 2014, which is pending in appeal being case number such and such. Subsequently, the order passed by the Appellate Forum on 28/1/2017 in connection with appeal cases number such and such arising out of CC 116 to 119 of 2015 situated at Shibpur. Similar, the cause of action are these orders passed by the District Consumer Forum and the State Commission. Now, my lord.
No, he is not challenging those orders.
Yes, kindly seize the.
But he is praying for the self-same relief, which
kindly seize relief D.
Oh, D.
Seize D. A, B, C, then D. This prayer, D is the main prayer. It has been sandwiched as D somewhere between A to C and E to L, so as to lend the credence of bona fide.
Yes, what is the finding of the learned tribunal?
I have there to Mullet, none of these orders have been annexed, but they have been relied upon in the plaint, so the learned judge below could have looked into it.
There are two views, Mr. Bordhan.
No, now Supreme Court 2020 says, by implication, they are a part of the plaint. Now, Mullet kindly sees the order passed by the learned judge in the court below.
Yes, what did the learned judge say?
He says, Mullet kindly sees the ordering portion, hence it is then the paragraph before that. This court holds the opinion that there are certain issues which must be necessarily be adjudicated through examination and legal consideration. At this stage, this court is unable to decide whether the suit is barred under res judicata or not. The court finds a prima facie case to go to trial. The factum of the orders being passed by the District Forum and the State Commission.
You are not on res judicata. You are saying that.
I say these issues have already been decided and
uniform res judicata.
Yes, and orders of the Consumer Forum cannot be challenged before the civil court.
Where is that bar? Do you have a copy of the
judgment?
No. Consumer. Which section?
Section 24 and 25. Old Act. It's the old Act, 86 Act.
86, no, now it's the 2019 Act.
But this suit was a 2017.
2017. I think similar provision in 2019 also must have been there. 24.
Yes, 24.
Finally, here.
Any decision on this final? What expression final?
Finality, yes. Kindly sees the first judgment I'll be referring to, Millard, is 1995 3 SCC page 583.
This is on section 24.
Yes. The relevant page would be page 594.
Yes.
Millet sees, this is paragraph 13, starts from Millet page. It starts from Millet page 593. 593, yes. Millet kindly sees 594 Millet sees.
Will be final. So this is
By virtue of section 18, the procedure prescribed in section 13 applies to state commission as well. From the above provisions, it's clear that the orders of the district forum, state commission, national commission are final as declared in section 24 and cannot be questioned in civil court. The issues decided by the said authorities under the act cannot be re-agitated in a civil court.
Yes.
This issue has been set at rest by the consumer forum. Then Mulad kindly sees, this would be Mulad 2017 volume 4 ICC page 180. Mulad, our High Court Mulad, relevant paragraph would be paragraph 30, where this 30, where the issue of res judicata has been gone into.
Res judicata, Mr. Bordhan, if you take
Similar quotes.
No, not that. Then the question of those plain issues.
Yes.
So it has to go to the evidence stage. That's the difficulty.
Mulad, I have two
So that
submissions
is
to make. I have two submissions to make, Mulad.
because res judicata is a mixed question of law and fact. So you have to produce those.
Mulad, that is the reason, Mulad, why I said this, Mulad. The orders of the District Consumer Forum and the State Commission had not been annexed. But, Mulad, reference thereto is in the plaint. So that is to be constituted as a part of the plaint. And the court can look into it. Kindly looks at both the orders. Those were annexed. Issues have been decided once and for all. So, Mulad, kindly sees paragraph 30, Mulad.
Yes.
He says it might not be res judicata, but there has to be a finality on the findings.
Provisions analogous thereto.
Yes. Yes. Now, Mulad.
So res judicata is nothing but finality. Finality to a litigation.
Yes. So, Mulad, once
it should end at one point.
I bow down, Mulad. I bow down. So, after Mulad having considered before the Consumer Forum, Mulad, was it open for her, Mulad, to approach the civil court? That's the question that falls for consideration.
Anything more, Mr. Bordhan?
Mulad, kindly sees Mulad Order 7, Rule 11, Mulad, the other judgment, Mulad, 2020.
That is, the other documents can be considered.
Yes. Mulad, 23.6 at page 12.
Paragraph
23.6 at page 12. Under Order 7, Rule 11, a duty is cast on the court to determine whether the plaintiff disclosed the cause of action by scrutinizing the averments in the plaint read in conjunction with the documents relied upon, or whether the suit is barred by any law. So, Mulad, the documents can be looked into. Then, Mulad, 23.13. If on a meaningful reading of the plaint, if it's found that the suit is manifestly vexatious and without any merit and does not disclose a right to sue, the court would be justified in exercising power under Order 7, Rule 11. Yes, Mulad. At page 14, Mulad, 23.13. Then, Mulad, 23.15.
Shall.
Mandatory.
Yes.
So, Mulad, read in conjunction, Mulad, the learned judge in the court below ought to have rejected the plaint on such score alone. And Mulad kindly sees the judgment of the order, the impugned order, Mulad. No consideration worth the name, Mulad.
I'm remanding it back.
Mulad may, but this rejects the plaint from here, once and for all.
That can be done, but Mr. Bordhan, have you seen the latest decision passed by Justice Bagchi in the Supreme Court on Order 7, Rule 11? Though it was not on that issue, not on order 7 rule 11, it was deciding a different point, plaint was rejected. But one thing there, are you carrying that decision? Because one thing, if I correctly remember, is that a remedy by way of an appeal, the party will lose. So if here this exercise is being done, one thing is to relegate. So whatever it might be,
this is the second relegation. This order has been passed after an earlier remand.
That is
by this court.
That is one way of looking at it. Another thing, because there is one thing, the reasoning was that is an appealable order, rejection of plaint.
Yes.
So a party has a right to prefer an appeal.
Yes.
So that right of appeal, whether can be taken away. So if that proposition is
I appreciate. So and coming from a judge who has practiced civil litigation for over the years, I am not amused. That is of course a consideration, Mulad. But in that even, Mulad, now to kindly test this in the backdrop of this.
You are right. That was on a
maintainability.
Yes, on a different while deciding a different
issue.
Assume an interlocutory application. Court finds no plaint is because plaint can be rejected at any stage.
And it does not
plaint
enter
was
an application.
rejected. So it was said that no, it could not have been done because
that's moral line. Moral.
But that observation, the reasoning
that's more or less subject to correction, Mulad, on the lines that you cannot grant a final relief while deciding an interrogative application. On those lines, Mulad. But this, Mulad, is a case where the plaint is liable to rejected, Mulad. On ex facie, Mulad, vexatious, ex facie.
I'm only thinking the right of we have not a forum to test this in appeal. And the plaint right of a party, that is Mr. Bordon, that's not an appeal.
No, special lift to appeal. If the Supreme Court feels this order can be appealed against.
That is a different thing altogether.
I appreciate.
It's it will be a regular first appeal.
I appreciate.
It will be a regular first appeal. There is no question of that, admission and other things.
If that if that is the proposition today, my lord is laying down, then any application or order 7 rule 11, if rejected at the before the court of first instance, we will not be able to assail the propriety thereof successfully before a revisional court. That is another aspect.
Mr. Bordon, when I looked at that decision, this got in my mind first, because otherwise no use of 227 against that. If that cannot be reversed, reversing means rejection. If that cannot be done, it should be said that that order is not revisable order. Or 227 should not have been entertained
in the first issue.
I don't think that that decision proceeded to
that extent.
Consider that, because that is one. Yes, what do you say?
My lord, since the plaint
has... anything more?
No, nothing more. These are the short points.
Now, my lord, this, so far as my instruction goes, my lord, I would have preferred to file a reply, my lord. If subject to my lord.
It's the point of law,
my lord.
From your plaint, from your...
But my case is that when this particular property has been handed over to the developer.
Sir, I cannot go to the merits.
I'm not going into the
merits, The question is, please kindly come to your reliefs claim, whether you can challenge an order passed by the State Commission in a suit. That's what is judgment. Please make submissions on that.
I'm making.
And Mr. Bordon has placed.
I have relaxed, my lord. I would like some time to say on that. But my lord, the issue remains that when this agreement, the whole conception of the entire litigation, whether before the district forum or before the learned trial court, is that the entire...
How can it be reopened, sir?
I am not reopening.
One way or the other, it has been decided. Maybe in favor of you, maybe against
summary proceeding. My lord, my humble submission is
finality.
My humble submission is in my summary proceeding, my signature, which was forged, it is under challenge before the police court. I mean, before the police, an FIR has been filed, which is it is stated there in the plaint. No whisper on that. My lord, that act of forgery has not been decided even in the consumer forum, district forum.
They approached before the consumer forum.
They approached. They approached.
Why did you not take this point that the consumer forum do not have jurisdiction? Yes.
That point was not allowed, my lord.
They have taken but not allowed. It's not that they're not raised.
And even in this trial court, my lord, my contention is that my share, without my signature, the entire property cannot be gone. I have only asked for a handwriting expert. If I am wrong, they have already won the case in the consumer forum, so that will remain. If the handwriting expert is engaged,
Sir, handwriting expert is the.
and if it is found out,
Sir, you have to first show that the suit is maintainable. Then I can go to those issues.
I have only asked
Unless
for
the-
my share. It is a litigation between my co-sharers.
That is on merit, sir. Sir, there is a technical issue. Mr. Borton says suit is plaintiff is liable to be rejected. Nothing can be seen from there. Considering your reliefs, you may have a very good case on merits. You may say you may have a you may say yes, the judgment of the state commission is bad. It's liable to be cannot stand the moment scrutiny. So this to be, but till it is upset, civil court cannot do that. That's the decision which he has cited.
My lord, I will like
the expression final. That is why
I have
I asked
seen
him
that.
to place this line of
I did not, but my lord, in case of any judgment before any court, if it is done on the basis of illegality or any criminal act, this case, it is the case of forgery. So nothing will stand in the way for a civil court to look into my rights.
Sir, where is your case made out that the this proceedings is vitiated by fraud? You have there is a proceeding was initiated before a constituted forum. That forum has decided one way or the other. So there is no question of fraud being practiced.
Until and unless the police gives a finding.
That is a different thing. Whether police will give, in which way, those ifs and buts cannot be
That is
decided.
Institution of that particular. And so far as my lord, the judgments relied upon, my lord, I'll need some time to look into it, my lord. If my lord is remanding it back, I'll not stand in the way.
I don't want to remand.
Because the next date is day after tomorrow.
Yes. So
And whether the suit is maintainable or not, my lord, even the learned trial court has not yet said that it is not maintainable. It may be so, it might go in their favor.
We have seen what the learned judge in the court has done.
Yes, it has said it's maintainable. Means that
Not at
the application has been rejected. That means the plaintiff. Yes, suit is maintainable.
No, my lord, the last line, my lord.
Yes.
There is a go for trial and the jurisdiction
Yes,
decided.
he says there is no necessity to go for trial. According to him, there is no necessity to go for trial. Considering nothing, he says, don't look at my defense, don't look at my application even. Look to his plaint. By looking at his plaint, it is not. He has not placed anything from his application.
Nothing.
Anything defense, nothing. He is only relying upon your plaint. Your document only.
Malik kindly keeps it next week then. I'll consider this application today. It came up, my lord. These judgments will come up and I'll place.
Then stays the further progress and fixes the date.
What is the next
Day after tomorrow.
After tomorrow.
Handwriting expert. My lord, that is a bona fide I am saying.
It has to be granted because prima facie. By the order It's an interesting point. And yes. এই বইটা দিয়ে দিন। ঠিক আছে। Not today, next. Not today, next.
Other six matters. 1456 was the 1456.
1456. Huh?
Stay in the list.
1456. For 56 by mistake it has come. It was not mentioned.
So then this matter will be fixed anything. The last three occasions I have moved this matter. The other side didn't came.
Did you mention this matter?
It was mentioned. It was fixed.
When did you mention this?
There I don't remember the date, Lordship. It was.
এটা দেখে নেবেন তো মেনশন করলে date. In this, where is Mr. Aniruddha Chatterjee? Yes, Mr. Chatterjee, where are you? Dismiss for default.
No, I'm here, below. He's held up, below. My learned friend, below, has asked to no dismiss for default.
I have seen you. You are present. If you is present.
No, present during the matter.
Yes, what is this?
Sir,
matter?
it's a. I want
not allow you to appear alone.
That is my problem. That is exactly why I said. Hey, Kushu, hey, I'm saved. This is a problem with this part of the. It's
yes.
A section 42 is allowed of the Arbitration Act on the ground that they have filed 3 section 9 applications before the High Court.
3 section 9?
Yes. There are 3 rounds of section 9 applications which were filed before the High Court. Lord, I will try and show your lordship that Lord, filing of a section 9 is not a bar, my lord, under 42 first, because that section 9, my lord, is with respect to, my lord, an application. Your lordship sees the language, it's an application. I am saying, my lord, that the proceedings which are here before your lordship, or rather on which, my lord, we are trying to, my lord, argue, is a proceeding, my lord, with respect to land. And if it's a proceeding with respect to land, then it squarely falls under 2(1)(e). If it's under 2(1)(e), my lord, it's as good as section 16 of the Civil Procedure Code. So wherever the land is situated, the cause of action is there. This is the subject matter, my lord, of the entire matter. The learned judge has held that since a section 9 has been filed before the High Court, she doesn't have jurisdiction. The commercial court at Rajarhat doesn't have jurisdiction to hear, my lord, the section 37.
In terms of section 40.
In view of section 42. But grossly erroneous, my lord, on 2 counts. First count is.
What is the dispute in the arbitration?
Eviction. Eviction.
Eviction. Under?
My lord, under Transfer of Property Act, that is subject matter I will not open my mouth on for the moment. They have filed a suit for eviction on the ground of, my lord, eviction on the ground of transfer of property. I'm sorry. Arbitration doesn't come out so easy. Arbitration. Yes. So, my lord, now of course, my lord, the Supreme Court has said that eviction suits, even
rent control legislations. Buzalen was
by Justice Nanima. Even Justice Chatterjee's old decision about fraud being Miller one of them, that was also Miller not.
Now it's everything can be
done
decided
by the arbitrator.
unless it goes to the root of that agreement and complex questions of
No, even complex questions of fact also now Miller Supreme Court is saying it can be done by arbitration.
But yes, some
Which I
decisions
cannot
says
agree.
that
That was
complicated
Justice Chatterjee's decision, Miller.
after following that some decisions.
No, they have now given a go by to that. It's a Justice Nariman's decision is, if I'm not mistaken, a 5 judges bench decision, where it gives a go by Miller to the earlier judgments. So now even complex questions of facts,
because that was the distinction
fraud,
when
yes,
it was being diluted. So only exception was that complicated questions and it goes to the execution of that agreement itself. So those were excluded.
That's also now gone, Miller. Everything can be done in arbitration. And anyways, that's I should not say. So, I used to tell my father that it's like an IPL for the after retirement. It's more like that's a different thing altogether. The question, Miller, before the question of law is on that, and your lordship needs to decide on that. I'll show your lordship if your lordship wants me to, Miller, finish and begin. I don't have a problem.
Can you finish within 15 minutes?
Difficult. It's going to be difficult, but
then what's the urgency that it's being fixed at 3 p.m.?
Eviction.
Section 9. They are sitting tight on my property without paying me anything.
Yeah, that is a different thing altogether. আচ্ছা ও তো কি বলবো কেন এরকম করছিস
Then there has to be a procedure on this. Otherwise, these issues are to be decided. It will take time. So it is to be harder.
Fixes any day, Mulad. Any day.
Yes, but pending that it is to be stayed.
Nothing remains to be stayed, Mulad.
No,
there's no stay.
No, stay.
His 34.
Lord, I'm not saying Lord stay. I cannot, because at the if there's an order of stay, then the entire thing will be allowed. I am saying don't disturb my possession for the moment.
That is Mr. Chatterjee.
Fixes any day, Mulad.
This is a 96 hectare. So there is no stay. 34.
Yes, because your prayer was for stay.
Yes. I will not. তারপর ওর কাছে তাহলে আমাদের কি আছে
2nd of August.
Milo doesn't do it with anybody else, I'm sure. Whenever I am here, I'm sure that your lordship finds out these weird dates when I'm sure there will be a resolution that we will not appear in court.
Mr. Chatterjee, so you will your heart's content, you can make your submission.
That's exactly why I don't want to. I don't want to break my resolution. Why not, Milord, on 4th, may I ask this question to myself?
4th
of August. That's the monthly listing. 5th of August.
So that's the difficulty, because when to be taken up, you know the fixing.
My Lord's diary any day, Milord. Because my Lord Justice Sarkar has said that after we finish this,
that has to be
lordship will hear that. So that's the only problem that we are facing. My Lord has said
even me
that it's not Justice Bhattacharjee. His lordship needs to decide this first before my Lord Justice Sarkar can proceed with anything.
So I can do one thing. Since the same issue is there,
send it back there.
I'm releasing this to be placed because I think analogous hearing will be. The strategy that will be better, because
no. Any day, your lordship, please, whenever. Because it is true, lordship has said below that once this is over, then his lordship would, her lordship would, ladyship would take it. Whenever.
That is the safest day, Mr. Chatterjee. That is the safest day. Mr. Bordon is ready. Mr. Chatterjee, Mr. Bordon is ready on that date.
On 2nd, very well keeps it.
But he has to start. He has to start.
তুই আমার দিকে একটা আঙুল দেখাচ্ছিস Keeps it on second.
I do not know what will happen fixing on that date. I'm only thinking. Let it remain, Mr. Chatterjee, let it remain in the list. So if not, please mention that I will
Lord,
keep it on
if it is taken up, Lord, any time before.
Before it's difficult because considering it will take time. Others are motions, Mr. Chatterjee. That is the only difficulty.
Seize your Lordship's diary whenever your Lordship pleases, whenever it's.
So I'm keeping it here. Let
On
it
second.
remain. I'm not fixing it on second because I do not know because
No,
that's the
then,
tentative date. What will happen? Any
Can
change on?
yes.
Then it will be a difficult thing. Then it will go there. It's difficult. Let it remain in the list. Prior to that, 1 or 2 days before that, you will know what will happen. If that mention, I will be fixing on 2nd of August is not a problem.
Very good.
So with that understanding, I am keeping this matter.
So it's tentatively on the second. If not, we'll come and mention before your Lordship.
Yes.
And
I'm
your
not
Lordship.
fixing on second by an order. I'm only keeping it, retain its position. If it is can be taken up prior to that on a convenient time, later half of the day, 4:15, 4:10, we can
Then your
start.
Lordship will not record an order. What's the point?
4:10.
No, I will record it.
Every day order recorded.
আমারটা যে করলো না যে একটু আগে।
No, that is because of resolution, not because of. Mr. Chatterjee, you have argued after 4:30. On order place, that is the order which you have cited.
I did not argue. I was forced to argue. There's a difference.
So your name was recorded, order was passed.
I cannot go, my lord, above the
In
court.
bold letters, your
has-
names are appearing.
bold letters? আমার নামই bold letters এ আছে।
In that order, I have seen.
Last record করেন, we could afford it. We cannot.
Heard Mr. Chatterjee Yes.
This was fixed matter.
26, who is appearing?
Mr. Bakshi is appearing for the opposite party.
Mr. Bakshi.
Yes, madam. For today, he could not come. Madam, 3 p.m.
All
fixed
right.
at any.
Yes, Mr. Mahato. You are opposing.
He's not opposite.
What is this matter? Oh, this matter, Mr. Bakshi said that he will not come. Yes, you start. Yes, you start. So you wanted to cite a decision of the division bench in first appeal. Please show me that. This was on statements made in the written statement, how to be controverted, whether it is necessary to amend the plaintiff or not. That's the issue. Yes, show me.
But Justice Bhattacharya's decision, I told my lord that I could not find, but I find my lord Supreme Court decision, my lord. Where
Supreme Court, yes,
which says, my lord, replica can be filed.
Replica, Mr. Mahato, that is a different.
Caption maybe.
No. Yes, caption may be order 8 rule 9 you can file. That's a different thing. My question to you is whether it's necessary to controvert the averments made in the written statement by way of amendment of plaint. That's the because replica is a different thing altogether. Replica is not a matter of right. That is pursuant to the leave granted. So replica and this is a.
I submitted your lordship that by way of replica it can be filed.
Not by way of an amendment.
Mind you, it may not be by way of amendment, by way of replica it can be filed. Well, this is my lord, says my lord, the replica to controvert the statement made in the written statement that can be allowed. 2024 9 SCC page 353. 2024 9 SCC 353. My lord, here, my lord, the suit was filed. My lord, first paragraph, the appeal is directed against order of the High Court of such and such, whereby leave has been granted to the election petitioner to file a replication in answer to the new facts asserted in the written statement filed by the written candidates. My lord, the paragraph 3, the statement of the plaintiff and the allegations made in the written statement has been stated, and as a result, last two lines, as a result, the election
paragraph?
Well, paragraph 3.
Paragraph 3.
First 4 or 5 lines, my lord, regarding plaintiff. Then, my lord, these allegations, however, were not only traversed in the written statement filed by the written candidate, but additional facts were also laid out therein. As a result, the election petitioner filed an application seeking leave to file a replication which came to be allowed impugned order such. My lord, the Supreme Court has relied upon a High Court decision, Delhi High Court decision. And my lord, paragraph 24 of that decision, it is at page 359, middle. Paragraph 24, admittedly on a reading of the averment set out in the subsequent pleading, replication, it is clear that they are the clarification and amplification of the earlier pleading made in the election petition. And if the pleading of the election petition is read conjointly with the pleading of the replication, the pleading of the replication are the addition of facts of the earlier facts of the election petition, and the annexed document are also related with the earlier facts of the election petition. In other words, the replication of the petitioner is to controvert the averments made in the written statement to the election petition. That apart, prima facie, the averments pleaded in the replication are not contrary to the averments made in the election petition. In fact, they are only explanatory and plea taken by the first respondent in the written statement. Well, just like our case. Next, my lord, paragraph 26 of that judgment. Next page. My lord was of the view that it will be going on. Amendment, additional statement, amendment. But if any new facts is, my lord, brought on record, that is required to be controverted. At page 36, Mr. Joseph David. Expediting and on.
Yes, yes. Please come to paragraph 29.
Yes.
Further, while considering last 5 lines of that, further while considering
paragraph 29.
Paragraph 29. Further, while considering grant of leave, this is order 8 rule line subsequent pleadings, replication by whatever name you called. The courts must bear in mind that a replication is not needed to merely traverse facts pleaded in the written statement.
Then the
Yes.
application is not substitute for new amendment.
Yes.
Next, a new cause of action or plea inconsistent with the plea.
Yes.
In the
So my question to you is that whether an amendment is necessary to deny or traverse with the facts stated in the written statement. Replica is also not that. Supreme Court has.
No. My lord, this, my lord, kindly
That is well settled. You did not traverse the averments made in the written statement by way of a replication.
No, my lord, this
So,
paragraph.
by way of an amendment, so now replication Supreme Court judgment is here.
This application has been allowed.
Maybe the application has been allowed, maybe replication, but while granting leave, these points are to be considered.
The first point, replica is not needed to merely traverse facts pleaded in the written
That's
statement.
my question to you. Whether that can be, for that replication or amendment is permissible.
Kindly see my application.
That was my question to you. You said that is permissible.
Yes, sir. My lord, if your lordships kindly before that, my lord.
Show me your application for amendment.
Paragraph, my lord, I am reading paragraph 29 as a whole.
Yes.
However, such leave is
Paragraph
not to be
29.
granted. Paragraph 29 of this judgment.
Yes. No. Show me your paragraph 29 I have seen. Show me your application.
And 11. Stop.
You have filed an application under order 6/17. Yes. Show me that.
My lord, 10 ক
Page.
ভূমিতে
Page,
my lord, 11.
There is no pagination, Mr. Mahato.
মানে করেনি জোসেফ পিটি করেনি।
Just after affidavit, my lord, kind of a
First annexure.
first annexure, my lord.
First annexure.
Yes.
Just after affidavit.
Oh, sorry. What is this? Oh, sorry. One bunch was given. Sorry, what is the page?
Oh, that is the plain and written statement.
That is the plaintiff.
Page 11.
Page 11. Yes, that is page 11.
সংশোধন 1, 2, then 10 ক নালিশি ভূমিতে বাদীর দীর্ঘকাল অনুপস্থিতির সুযোগ লইয়া বিবাদী জোরপূর্বক নালিশি ভূমির তদস্থিত গৃহ দখল করিবার জন্য নানারূপ চক্রান্ত করিয়াছিল। সেই কারণে বিবাদীগণ তাহাদের দাখিলি বর্ণনাপত্রে বাদীর সত্য দখলি নালিশি ভূমি ও তদস্থিত পোক্তাগৃহাদি বিক্ষয় বিষয়ে ভুয়া মিথ্যা কাল্পনিক চুক্তির বিবরণ উল্লেখে একটি আষাঢ়ী গল্প।
So it's only denying statements made in the written statement. Nothing more than that. You have only denied what they have stated. You are denied.
My lord, paragraph 10 খ.
Paragraph 10 খ is mere denial. Paragraph 10 খ.
My lord, I have stated something more. I have
Yes.
stated about the
What
blank
is the
paper,
more?
signature on the blank papers.
চুক্তি হয় নাই। My lord, that is denial of.
Yes, so they have said and you have denied that. চুক্তি হয় নাই. Mere denial.
মানে বাদী কোসমিল কালে ভূমি বিক্রয় বিবাদীর সহিত চুক্তি করে নাই, দিস ইজ ডিনায়াল।
Yes.
দেন মাই লর্ড, এতদ ব্যতীত পূর্বোক্ত ঘটনাকালে সংগৃহীত ঐরূপ ফাঁকা কাগজ সমূহ বিবাদীর কাস্টডিতে থাকায় বিবাদীগণ কোন পাতি বুদ্ধি সম্পন্ন ব্যক্তির কুপরামর্শে ওইসব কাগজে বাদীর নামকরণ নালিশি, দিস আর মাই লর্ড ফ্যাক্টস।
No,
It is
my
not
lord,
denial.
that is answer to my written statement, my lord.
All right.
31 and 32.
All right. When Mr. Bakshi will be available?
Picks up any day, my lord.
When? Please tell me which day he will be available.
Thursday.
This Thursday, Mr. Mahato?
17 I have not even.
17th? 17th of July you said? Not this Thursday, next Thursday. All right. On the prayer of Mr. Bakshi. Yes, call the fixed matter. 48 না কি 53 না কি বললো যে
তোমারটাই বলছিল মনে হয়।
48, yes. Any opposite party is there?
Yes, Mr. 48 to 51, I think.
Yes, 48 to 50.
50. Three matters.
Yes. Very urgent, Mr. Mukherjee.
No, my lord, today I have been informed the date is being fixed on 4th of August.
Yes, what was the urgency? What is the impugned order?
My lord, my application is,
Additional applications.
my application is challenging the refusal to transfer the my lord, suit by the district judge under section 24 of the Code of Civil Procedure.
227 against that.
27 against that. Another, my lord, I believe my learned senior is appearing. That is, my lord, that is also, my lord, the plaintiffs, my lord, the defendant's witness have been closed. So, and the last one is Mr. Mukherjee has filed the application, 227 application, rejection of his prayer for amendment.
There are two sets of defendants.
No, he is for the plaintiff, I am the defendant.
Two sets of, no,
Yes, two sets of defendants.
that is why
Learned
two sets
advocate,
of defendants.
different matter.
One defendant, two sets of advocates.
Yes, in two different matter.
Oh.
Because in 24 I am appearing.
There is only one defendant, one plaintiff.
So I'm making it not to, because there is Mr. Bhattacharya says something will happen.
Yes,
Where is Mr. Bhattacharya?
He's waiting.
Will it be Lordship's pleasure to take it up day after? Because we do not know what will happen tomorrow.
No, tomorrow. Come tomorrow.
Resolution actually.
If you have extreme urgency, tomorrow. Otherwise, that will be taken up in due course.
No.
Tomorrow.
I do not mind if it is taken up in due course.
No.
Yes. Call 53 na koto.
But 53 minute kindly permit me to appear.
I have stopped.
But 53
Mukherjee, I am told, is going to appear.
Unless you bring them today.
But I am in virtual mode.
Junior is.
Virtual mode.
But I'm in
yes, in virtual mode.
I have also informed the private respondent.
For the private respondent, I
Because
was
the
being
private
led by
respondent.
Mr. Shojo Mukherjee, Your Lordship. He
But kindly see your lordship last order, my lord.
Where is he?
Lordship, he could not come to court due to medical emergency in his home, Your Lordship.
You are here.
Lordship, he was requesting if it can be kept tomorrow at the first sitting.
Tomorrow first.
All right, let me see what can be. Yes, what is this?
But my lord, kindly see your lordship last order.
Oh, there was a writ petition. Where is that writ petition?
In the writ petition, my lord, they have virtually, my lord, asked for regularization of the unauthorized construction.
And where is the order passed on 13th of June?
And I'm seeking your lordship's leave to file a supplementary affidavit disclosing all these facts.
But this was not disclosed earlier when I pointed out that time only.
No, I don't think that I am moving a petition under Article 226. This is not ever drafting. It is sheer ignorance on the part of the learned advocate who is dealing with the matter that he ought to have disclosed. He has not disclosed. It might at best be, an aberration. It should have been disclosed undoubtedly. I am not supporting non-disclosure.
Mr. Bhattacharya, don't you have another copy? Because this is your filing slip is there. Give another copy.
I will give a copy.
But kindly see paragraph 9.
Yes, Mr. Bhattacharya. What
Today, just need not open the papers for a moment.
Yes.
Today I have come before your lordship.
So what is this scan? Scan taki? So scan you have scan ta kunta 850. The scan you have also given. Mr. Bhattacharya, this scan is with this.
No scan has been supplied to us.
All right. No, not can in this. It's the can in the other writ petition. Yes, Mr. Bhattacharya. What is the challenge?
Lord, today I am assailing an order of the tribunal. In the writ petition that is before your lordship, that has been made by abundant caution. It should not have been made according to me.
No, but what is the challenge in this civil revision application?
In this revisional application, an order made by the tribunal, whereby, I had taken out an application saying that, my lord, a particular document is lying in your file which apparently was never issued or signed by me. What is that document? My lord, during the hearing before the hearing officer, before pre-tribunal stage, before the special officer building, my lord, I had attended a day's hearing only on the question of regularization. A discussion had taken place. It is not something so blatantly illegal.
Who are you?
My lord, I am one of the co-owners of a two, my lord, garage space which I have purchased.
Two garage?
Yes, which I have purchased, my lord, from the developer, from the developer's allocation. Incidentally, the developer has sold the same portion to one Iqbal, which prompted me to go elsewhere, my lord, before the consumer forum. There are proceedings there. In one such order, my lord, I have disclosed that in the supplementary affidavit, my lord, a coordinate bench of your lordship's court, my lord, has passed certain orders in a division, which is not the subject matter here. During the SOP's hearing, I attended a single day, nothing beyond that. One fine day, I am served with a writ petition in 2022-2023, saying that the SOP's order need to be implemented. I rushed to your lordship's court. I was arrayed as a party. I rushed to your lordship's court. The single bench, my lord, whoever my lord was, my lord, was not inclined to give me relief. I carried an appeal from the order. The honorable division bench of this honorable court, initial order and final order, directed the tribunal, directed the corporation SOP's office to give me a certified copy so that I can carry out an appeal. I can prefer an appeal before the building tribunal. In the building tribunal, the private respondents were added as parties. The matter was being heard. At some stage, in order to oppose my section 5, what the private respondents did, that all throughout, applications have been made, documentations are on record, oral submission recorded, and they tried to impress on the building tribunal that I am foreclosed from questioning anything because I had all throughout participated, and therefore the section 5 application, whatever the explanation offered by me, is not correct. At that stage, I took out, you know, whatever is an application, you know, today the initial it was 340, you know, in the BNS 379 BNS, you know, I took out an application saying that this documents, first of all, it needs to be investigated upon whether I have really issued those documents. First question is
That is the order of the SOP.
Yes, it is in the supplementary. In the civil divisional application.
But supplementary affidavit has not been supplied.
Yes, I am taking your lordship leave today. I will give a copy. Let us come back if they want. I do not mind. The matter is fixed tomorrow. That is the urgent.
No, regarding that, your lordship has already heard. Kindly hear the matter then.
Regarding what? You know, the SOP's order is page 36.
But what he wants before your lordship, my lord, it is a dispute between.
Corporation cannot have any say, my lord. It is a BT appeal. I am carrying an order.
He is challenging my order. He is challenging the order of the corporation. There, my lord, what corporation had said that whatever steps he.
In your voice, you have the microphone now. Don't strain. Why are you straining your voice?
Unfortunately, there are certain things which I can't disclose to your lordship. There are certain things much more than what meets the eyes. My lord, the corporation in usual matters do not choose to appear. Not even on caveat they appear.
Not. This is not right. Mr. Varchari should not say this. But kindly remember, yesterday also I appeared. This should not be said by Mr. Varcharia.
Maybe on instruction. I am not blaming Mr. Mukherjee. Why should he take it personally?
Now, why when he is saying that corporation is not appearing, whenever civil division is appearing, when I am getting the instruction, I am appearing.
Yes. So someone must have instructed. So the question is what is the promptitude here? What is the overzealousness? I have carried an order whereby the tribunal was not inclined to give me a particular relief. Your lordship will examine the order.
Yes, what is that document you are saying that,
That document, I don't know.
no, where is that reference in this appeal?
In the order.
Yes.
In the main order. Kindly comes to the main order.
Yes.
Petition.
Yes.
Page 60. It begins.
Yes.
প্রথম থেকে পড়া অর্ডারটা, it cannot be done in this isolation. Please see page 59.
This is the certified copy. Which portion? Which internal page?
Internal page kindly comes.
No, there is no internal pagination also.
Please see. A petition is filed on behalf of the appellant praying formula. I am reading page 59.
It's not paginated because this is the certified copy.
Yes.
Oh, page 59 is also there. All right. You have annexed that copy there.
Yes.
Page 59, yes.
Order dated 25th April 25.
Yes, yes.
Now, please see, a petition is filed on behalf of the appellant praying for initiation of contempt proceedings and investigation against municipal authority and the added private respondents on the grounds stated therein. Copy served. Learned advocate for KMC objected to. Learned advocate for the appellant urged for taking up the petition praying for drawing up contempt proceedings and initiation of investigation before hearing of application under section 5. Learned advocate for private respondents did not want to file any written objection against the petition mentioned above. Accordingly, the petition filed today on behalf of the appellant is taken up for hearing. Learned advocate for the appellant submitted that from the affidavit filed by the respondent in this appeal, the appellant came to know that a representation dated 14 March 22 purported to be written and signed by this appellant was submitted before the special officer building during demolition proceeding. Said representation was neither written nor signed by this appellant. The said representation is false and fabricated document. The said representation dated this addressed to the special officer is lying with the court record of demolition proceeding. The said representation be kept in
Sir,
safe.
Mr. Bhattacharya, according to you, you did not submit any representation dated.
I did not participate in the hearing.
So according to you, you did not submit any representation dated 14th of March 2022. That is your submission. So what is the effect of that representation?
The effect of that representation will not apparently, a case has sought to be built before the tribunal that I have prayed for some regularization, some protection before.
You have not prayed for regularization.
First submission to your lordship is I did not participate. Forget about giving.
Participation or not, that's a different thing altogether. So 14th of March 2022 relates to a prayer for regularization, which according to you, you have not made.
Never made.
So let us take for the present that there is no prayer for regularization from your end.
From during the hearing, before the hearing officer.
Oh, now you are trying. Now you want to.
Yes.
Now is irrelevant here. The BT appeal is pending. My lord, I have undertaken in the supplementary affidavit that if the court feels, I shall withdraw my writ petition because the writ petition cannot
Mr. Bhattacharya, that's your choice.
No, that has been stated when I pointed out.
Direction.
I shall withdraw it because two proceedings cannot run today.
So do that. Come.
No, kindly visualize. Initially, he did not.
I'm not doing anything. It's after all, it's your choice. It's your decision. So how you proceed?
Kindly hear me. But this cannot be at this stage because initially he did not point out. When I pointed out, your lordship order is there. At this stage, my lord, kindly don't permit him.
Tomorrow.
Very well. Very well, I'll come.
Mr. Mukherjee will be available tomorrow.
Yes, my lord.
No, not
I'm giving you a supplementary.
Mukherjee, Shaurya Mukherjee.
Supplementary law.
Copy of the supplementary bill, sir.
Copy of the later order be passed, my lord.
100% order be passed. Order be passed.
Mr. Bhattacharya, please give.
Yes, I'll give us tomorrow. কিচ্ছু দেবে না ওখানে গিয়ে টাইম চাও বলো আজকে মামলা
ওই ফিক্সড 3 PM এ করে দিন।
Very well.
Will be available tomorrow.
Tomorrow 3 p.m. my lord, but there is an uncertainty, my lord.
I am available. I am available, my lord. Let Mr.
No adverse order is there tomorrow.
Hearing. If the matter is taken up by
3 p.m. If you cannot come, you can attend virtually.
he is attending virtually, my lord. Ask him to, no, I cannot ask him, my lord. He will take me to task. That he is doing other minting. He is minting money.
Yes, Mr. Mukherjee.
In government matter, on a government matter, I am appearing in arbitration proceedings.
Everything in a corporation matter, and he is Mr. Devjit Mukherjee. I have to believe it.
I know my name.
I also know your name.
ওটা যেটা করবেন এটা লিখে দিন।
আবার কি লিখবে?
Understanding.
আবার কি লিখলো?
To virtual mode, ঠিক আছে?
এবার তুই যেটা করছিস কর।
Your lordship is recording virtual mode.
3 p.m.
Sorry, my lord. Sorry to disturb you.
What?
Very,
I will have to say sorry because I could not take up your matter.
very sorry. Kindly do not embarrass me. Kindly do not embarrass me. Devji, তেরে কম কথা বললো।